Supplementary list for judgment, item number 42.
The conviction of the appellant, middle way, is scaled down from 302 to 304 to 10 years. 304 part 1 to 10 years.
Of land.
No.
Please, your lordship, I'd like to mention item number 13 and 14 for adjournment, lordship.
Right. Why?
Lordship, my senior is engaged in the Supreme Court, lordship.
It's
a little
because
upset,
the conducting counsel is not available today. List up to 4 weeks.
Lordship, the interim may be continued.
The interim order passed earlier shall remain in currency.
Much obliged.
May I please, your lordship, I wish to mention item number 19. With consent of the opposite parties, I pay for an adjournment of this matter.
4 weeks time is granted to further opportunity of 4 weeks is granted to Mr. the standing counsel for filing an application with better particulars.
May I please, lordship, I'd like to mention item number 23. Matter may be adjourned, lordship.
Why?
Engaged counsel is not well, lordship. Counsel, my senior engaged counsel is not well, lordship.
Otherwise, also the fate of your PIL will depend upon the outcome of 2 matters we are hearing in the supplementary list. List up to 4 weeks as planned. Okay.
May I please, your lordship? I beg an example for item number 22. In this matter, lordship, I have filed affidavit, e-filed yesterday and manual filed today, lordship. Affidavit in opposition on behalf of the respondent number 4, lordship. It may be called for lordship.
MS Bora submit that she would be filing the affidavit on behalf of the respondent number 4 during the course of the day. E-filing has already been done. Let the affidavit be brought on record. Re-notify after 1 week. After 2 weeks.
Lordship. This is so much of contempt, lordship.
No, item number 29, this is transferred from the adjournment, my lord. My lord, additional confirmed he has not received the copy, my lord. And another similar issue, my lord, writ appeal is pending before this honorable court, my lord.
Okay.
My lord, so my lord, matter may come after 3 weeks, my lord. In the meantime, I'll start copy to him.
All right. Copy of the writ appeal be served upon learned Additional Advocate General Mizoram, Mr. Kalita, within 3 days. Connect and list with writ appeal number
265 of 2023. My lord.
Connect with list rate appeal number so and so, re-notify after 3 weeks. You are for the respondent in this case.
Yeah,
no
private
objection.
Okay, the
Fine,
counsel for the respondent has no objection to prepare for adjournment. Yes, Mr. Kalita.
Item number 37 and 38, your lordship. I need a little bit of accommodation because lordship, the lawyers from Manipur were supposed to come. They were supposed to come, they could not make it, lordship. So, lordship, can it be after 2 weeks, maybe on a date fixed?
It is stated that the arguing counsel who was to come from Manipur for the respondent, for the state.
Petitioner.
My lord, I am for the state representing respondent number 1 and 2.
So for the private respondent,
No, I am for the petitioner, lordship.
for the petitioner, has not been able to come to Guwahati because of some issues. A request is made to adjourn the matters. The other side has no objection. Re-notify for hearing. Then it goes to October.
October,
Yes.
Lordship, September, any date, September?
September, we have fixed many dates already, sir. Re-notify on 12th October.
12th October.
My lord, my name may be recorded
Name of so and so shall be
for the state.
mentioned for the state of Manipur.
Oblige, your lordship.
Obliged.
May please your lordship, there is a matter listed tomorrow, your lordship, item 25. In that case, lordship, we have filed an IA, lordship. That may be called for lordship for tomorrow.
Go to the registry. You can't make a request for listing the or tagging any documents in the court when the matter is coming up tomorrow. We'll do it tomorrow then when the matter comes up.
Lordship, it's just
You
separate.
try it with the registry.
Yes,
The
I
registry will,
approach the
registry will do it.
Yes, yes.
Why you need to make a mention for that?
Much obliged, lordship.
Yes.
May it please your lordship. Lordship, I would like to mention for listing of a public interest litigation for tomorrow.
What is the matter about, madam?
This PIL has been filed against the lack of safety measures taken during the construction of the Malegaon flyover.
Lack of what measures?
Safety measures.
Safety measures. The flyover is to be inaugurated. Now you have woken up.
Lordship, recently the petitioners along with some of the other people has witnessed fire sparks falling from the construction
Now
site.
it is almost about to be inaugurated, madam. Today only there is a statement. What for anyhow get it listed. People who have to pull down every development project by any means.
Lord, may it please, Lord. Lord,
Yes.
I'm making a little unusual prayer. I don't know whether this should be mentioned in this manner. If I made a mistake, Lordship will
It's
kindly.
okay, please.
My lord,
carry on.
the issue is, my lord, I made an application before your lordships in the administration and on the last occasion yesterday, praying for permission to move a matter here in the principal seat pertaining to my lord Arunachal Pradesh. Lordship was pleased to
Next
reject-
week, the bench is there.
Lordship is absolutely correct, but the difficulty-
Transfer matter.
true, my lord.
Yes.
The only difficulty is that in the earlier round of litigation, my lord Justice Tagia, my lord expressed view in the merits of the matter that the transfer order is absolutely fine. There is no infirmity. Only that extent, my lord. That I just failed to explain before your lordships in my application, my lord. So already the my lord, it was merit was gone into, my lord.
Basically, Mr. Das, getting the appeals listed here, that means showing lack of confidence in judges who are sitting in the benches.
I'm
That
absolutely
is
not.
a
subscribing to that, my
little
lord.
extraordinary kind of situation. Then only we entertain these requests.
Lordship is correct, but this fact, my lord, I just failed to, my lord, express in my application, my lord, that Justice Tag.
We'll see, all right, we'll take it up in the administrative side.
My lord, I'll
Take
move an
time.
application, my lord. Highly obliged.
We'll see. All right.
May I be-
We'll see during the course of the day. Yes.
My lord, I also pray for similar, my lord, this prayer for listing, my lord. It's relating to my lord Kohima bench, my lord.
Why can't it come up in Kohima?
Yesterday, lordship has allowed us, my lord, permission, my lord, to file. We have already filed yesterday, my
Then
lord.
what do you want now?
My lord, for listing tomorrow, my lord.
We had already given you permission, all of that was on the administrative side.
Yes, my lord.
Get it
For
listed
my
tomorrow.
lord.
Yes.
I'm obliged.
Daily list for orders, item 18.
Notice has to go to the respondents after restoration, Mr. Borpuzari.
My lord,
That notice was only for the restoration application.
my lord, my lord.
Issue notice of the this writ appeal was dismissed for want of prosecution way back in the year 2016. It has been restored by accepting the application civil number 2484/18 filed by the state. In view of the fact that the writ appeal has now been restored after a gap of 8 years, 6 years, 7 years, let notice of the writ appeal be again issued to the respondents. Steps for service upon the respondents numbers 1 to 8 be taken within 7 days whereafter process be issued.
My lord,
Rule is made renewable in 8 weeks.
I'm so obliged.
Item number 21.
In this matter, last occasion, the lordship was pleased to direct the respondents to furnish the progress report with
Hmm.
regard to this road, my lord.
Yes. Who's there?
Mr.
Mr. C. Barua, Mr. R.K. Talukdar,
Yes, my lord.
Mr. C. Sharma. We'll pass it over, call the concerned council. Names are being shown.
Yes, my lord.
There is no name, Mr. Das, in the call list. The matter shall be re-notified after displaying the names of then council, Mr. Standing Council, NHI, Mr. C. Barua, Mr. R.K. Talukdar, and Mr. C. Sharma, advocate, in the call list.
Lord,
List on 24th.
deeply obliged.
Item number 24.
Yeah, please, Your Lordship. Lordship, service is awaited in this matter, Lordship.
So we have to await or issue fresh notice.
Lordship, if Your Lordship may allow, we will take justice, Lordship.
Issue fresh. Last time you didn't take the service. That is the problem.
Postal toll.
All right. Notices issued to the respondents have not returned after service. Let fresh steps be taken in 7 days. Whereafter, notices be issued. Basti service is permitted. Rule is made returnable in 8 weeks.
Item 25.
Your lordship directed for the service of the notice on the.
Respondent number 4 is you are appearing for ONGC.
No, my lord, I am for.
Who's for the ONGC? No one. All right. Then we'll post it for admission, Dr. Saraf.
We have filed the affidavit for the service of the.
All right. Then counsel for the appellant has filed affidavit of the service upon the respondent number 4. Where is the acknowledgement?
In the bottom of the. It was sent by.
No one appears for such respondent despite service. List for admission on. When do you want, sir?
Any that you can.
28th? 28th?
My
28th. And in the meantime, inform the standing council if there is any standing council. ONGC, please tell. Is there any penalized lawyer? Empaneled lawyer for ONGC?
Generally, Mr. Shahela. Anas Singh, he appears generally in the photo.
Please try to tell them. Because ONGC normally should not go unheard.
Till then, Miller, I think while NFN had assured that no further action will be taken on the last day.
That assurance still continues.
Not from my mouth, but for yes.
Hmm?
Anyway, my lord, on 2028.
Till 28th.
I'm obliged. No?
Item number 26 and 27.
May it please your lordship. This matter relates to allotment of a pharmacy canteen in a hospital in Falcon in Mizoram for 2 years period. The tender was issued in 2019, lordship, and page 62 is the terms and conditions.
Original file and writ appeal. What is the IA for?
They wanted to vacate the interim order.
That's why your lordship, the last
Uh,
time came.
We
Lordship, here the
indicated that finally hearing. them.
entered finally this.
Very well. The writ appeal is of 2019.
19, lordship.
And when was the stay passed?
Stay on the very beginning, at the very beginning, lordship.
So you've woken up after 4 years
Yes.
for getting the stay vacation.
So my lord, what to do? The matter comes up. We try to argue the matter somehow, my lord. All
It
the
has,
time.
Mr. Das, this appeal has never been listed for hearing once.
No, it has come for several, your lordship, orders, not in this,
Not before this.
not before, but your
Not for
lordship,
hearing for the first.
hearing for the first, but
Not
orders,
the writ appeal number 343. What about 342?
yes, your lordship will kindly see.
342 file. That is also listed today.
Your lordship want to, last time it came, then your lordship expressed that you will dispose the.
No, we'll hear it, not a problem.
Yes.
Who is there in 342?
342. 342, we are appearing, Lord.
You are appearing? All right.
My lord will kindly check that other 340. There are few orders there.
Just let's check. Maybe there, the stay may be there. In 343, there is no stay.
342, there is stay.
So your application is in 343.
Yes.
We'll dispose it off.
My lord can.
There is no stay.
There can be here the entire matter.
That was there in the lighter veins.
Yes.
So the interim order was passed on 4th of December 29.
So that is only in 342. So your IA is otherwise also
Yes.
not maintainable.
Yes.
Okay, now proceed, please.
Yes, Lord. The tender notice was issued in the month of August 2019. And
Just. Notices at page number.
notice is at page number, the condition, corrigendum is at page 58. That is the extension.
Original tender notice.
Original tender notice, page 15, it is in major. And
Page?
page 60.
60.
Joram Medical College, State Referral Hospital, Falcon. Pharmacy canteen short tender notice, which was initially notified to be submitted on 14/8, has been extended to 23/8/2019 due to some difficulties. Interested parties may purchase application form from the JMC office.
No, auction notice. You're talking of the auction notice or what?
It is a short
It's an
tender
auction notice. We have what title you have given at page number 59. When Annexure 3 is auction notice. It's not a tender.
Short tender notice. Short tender.
Auction notice. Read page 58.
They are utilizing the word very
Whatever
carefully.
the word is, Mr. Saikia,
But-
we have to go by that.
Yes, but it was not auction. It was formal bidding was there.
What is the language of this document?
Mizoram, Mizo language.
But then you have to give translation.
Yes, translation.
How do
is
we
also-
read it? Read Annexure 3, page 58. Where is the translation?
In supersession of the Joram Medical College State Referrals, advertised number 68/2009 regarding.
You are
tender,
reading from which file, Mr. Saikia?
Page 250,
Two.
342.
Because in 343, the translated copies are not there.
In my case, there are translated copies, Lordship.
343, it's not there.
Yes, Lordship.
Page.
Page 58. First letter, first on 68/9. This is the corrigendum, but 68 is not there in my petition, Lordship.
68 will have to be seen, sir, first.
Yes.
Where is 68?
In the second appeal, at page 62, that is in.
That is in the Mizo language.
No, no.
There's
it
no
is in English.
translation.
And then type copy is in next page.
Page 60.
Page 63 of 343.
A tender for running pharmacy canteen has been called.
Here it is said, page 63,
Hmm.
a tender for running pharmacy canteen has been called by the State Referral Hospital, Falcon, Joram Medical College from 17th August 2019 for a duration of 2 years.
Hmm. Yes, then what happened?
Reply to that so and so, then it was, the corrigendum was issued, the extension was regarding the last date of submission at page 58
58.
of the other. Then I take your lordship to my appeal, lordship.
Hmm.
Then in the short tender notice, the terms and conditions are at page 62,
62, you are referring from 342?
342, lordship, the English rendition.
Yes, yes.
The tender application must be kept in sealed envelope. On the date of opening of the tender, the applicant, all the applicants or representative of their firm must be present along with their original general drug license.
Hmm.
Lordship will kindly mark this general
Yes.
drug license.
Yes.
3, the selected pharmacy vendors must have a valid general drug license, schedule
Hmm.
H.
Hmm.
One Xerox copy of drug license must be attached.
Hmm.
4, the terms and conditions of the Food and Drugs Administration, Health and Family Welfare Department shall be followed with respect to storage and sale of medicine and surgical equipment. The managing board shall keep this available for inspection at all times. Number 5 is critical, Lordship. The pharmacy canteen shall be rented for a period of 2 years. These terms shall be calculated from the date of agreement.
Hmm.
ZMC SRHF Management Committee is signed. No person shall occupy the pharmacy canteen without an agreement. So, Lordship will kindly mark this. Only the pharmacy canteen shall be rented for a period of 2 years from the date of the agreement.
Yes.
So, this is the position. Now, thereafter, the tender was opened and comparative statement, Lordship will find at page 63.
Hmm.
Allotment order of copy to give a photo.
Yes.
There are 13 participants.
Hmm.
RR Pharmacy,
RZ pharmacy.
yes, that is for 2 places, RR Pharmacy and RJ Pharmacy.
Hmm.
RJ is the other party, that 343 is Appellant,
Hmm.
and I am Lordship RR Pharmacy.
Okay.
At Falcon, I have bidded for 47,300 per month.
Hmm.
That is the rent.
Hmm.
Then it was given to number 5,
Medicare.
Medicare at 60,000.
Yes.
He is respondent here,
Hmm.
and there is no reference whether his license is valid or invalid. here.
Wherever the invalid license is there, that is indicated.
Indicated, but here it is blank.
So yours also is blank.
Yeah, mine is also blank.
Yes.
Here is also blank.
Hmm.
Now his drug license area, Lordship will see the third column.
Hmm.
For me, this pharmacy canteen,
Hmm.
where it is located, it is Falcon area.
Hmm.
Here, my license is for Falcon area, drug license area.
Hmm.
The other one is also Falcon area. Then number 5, it is Darpui. That is a different area. Whether the main issue before this honorable court is that when we say that a valid drug license or valid general drug license, whether a drug license or general drug license of Darpui will be a valid license for an area in Falcon.
Falcon.
That is the question, Lordship.
Okay.
On that ground, the learned single just said, as he is having a general drug license, his tender is valid and he is eligible.
Okay.
My submission would be, Lordship, that it is not eligible under the Drugs and Cosmetic Acts and the rules framed thereunder.
Let us see those.
Every area must have a separate license.
Okay.
Rule 62 and Rule 64.
You quoted,
Yes,
that was argued before single judge?
that was not argued properly, and
No.
also the learned single judge. Yes, it was indirectly it was stated.
It must have been taken as a ground in your
Here
writ
we have
petition.
this is our main ground here.
Writ petition, read that ground. What is the answer of the state? Read the ground in your writ petition.
Writ petition is a page. Respondents, yes, Lordship, I'm coming.
Take your time, take your time.
It starts from page 20. Para 12, page 38, Lordship.
At this stage. Yes, against rule 61 and
At this,
62.
it is submitted a selection of respondent number 5 who does not have a license to sell for running pharmacy canteen, stock or exhibit for sale or distribute drugs at Falcon is against rule 61 and 62
Yes, all right,
of
let's
the
see.
drugs,
Let's see
which
the
is arbitrary, and
response.
their response,
Yes, para 12.
paragraph page,
Page 90
page
96.
54,
Page 54.
paragraph 7 and paragraph 10. These are the 2 justifications.
Yes, yes.
Paragraph 7 says, I say that though the petitioner and Laljaura were the only 2 participants contenders having pharmacy license at Falcon for running the pharmacy canteen, it is made clear that the tender was invited to persons having a valid drug license, general drug license, schedule H, and does not specifically invited persons having pharmacy license at Falcon area only to ensure greater participation for the general good of the public. The petitioner, if aggrieved with the terms and conditions, could have challenged the same before opening and or before submitting her bid. Accepting and not being aggrieved with the terms and conditions of the notice, the petitioner has participated in the said tender. The petitioner could not blow hot and cold at the same time. Paragraph 10. What is important, on that day, he was not having a license of Falcon.
Falcon, he acquired it later.
Later, the last date was 23rd of August. He applied on 11th of September. He got it on 17th of September. And the impugn order was
13th
issued on
September.
13th September, and impugn order was issued thereafter. So they also knew that the valid license must have a, what the reason being very clear, Lordship. Every area must have a
Let's
license.
see the rules. Let's see.
Yes, rules. Because every area must have a storage
License,
capacity.
your argument is license is area specific.
Area space.
A person having license for one area
Yes.
cannot do business
Exactly.
in another area.
And when we say valid means validity should be for that particular area.
Yes.
Rule 62.
What is the stand of the Drugs and Cosmetics Department? Has the Drugs and Cosmetics Department, was it a party? No.
State is here before.
State is there.
The
What is the
Directorate
stand of the
General is
state?
appearing.
My lord, kindly see section 62.
Rule.
62.
Let's see that.
Rule 62.
That's what Mr. Saike is pointing out.
Rule 62.
Yes, just a moment.
May I read it, Lord?
Yes, please.
Rule 62 says, sale at more than one place.
Hmm.
If drugs are sold or stocked for sale at more than one place, separate application shall be made and separate license shall be issued in respect of each such place. Very categorical. And Rule 62B says, conditions to be satisfied before license in Form 20A and Form 21A is granted. A license in Form 20A and 21A shall not be granted to any person unless the authority empowered to grant the license is satisfied that the premise in respect of which the license is to be granted are adequate and equipped with proper storage accommodation for preserving.
That would be for the canteen which will be done. 62(2)A would apply for the canteen.
Exactly.
If you are going
But
by
a license also,
Hmm.
conditions to be satisfied before a license is issued.
Hmm.
So these are conditions because every license has to be given, just like a liquor license, Lordship.
So
If I am
the-
having a
the
IMFL
person
shop,
who applies for a particular area must have a
proper storage
premise
of
proper
for
storage for that particular area.
Lordship.
Yes.
And Lordship, it was given to a person at the behest of the Chief Minister and the health. All these note sheets we have annexed.
Mhm.
Clear case of nepotism.
Okay, let's see what you're pointing out.
Page 24. Page 24, Lordship will kindly say to the Honorable Chief Minister, Government of Mizoram, application for transferring drug license from Darpui to Falquin.
Mhm.
I have participated in the pharmacy canteen tender. He is not a participant, Lordship.
He is not a participant.
He is not
means
a participant also.
Who?
I'm coming. Let me read the whole
This
letter.
person who files the application is not a participant.
I am coming, Lordship. I have participated in the pharmacy canteen tender for Joram Medical College and State Referral Hospital, Falcon on 9/8/2019. In the name of Joram Thanga Drug License, Medicare, so-and-so, Darpui, so on 22/8/2019. I highly expect that I would get the work. I immediately want to transfer the license mentioned to Falcon area since Dr. Jad Joram Mawala has agreed to the transfer. I request you to get the transfer of the aforementioned license done immediately. I kindly request you to get my request done. 11th September, 23rd August was the last date. So this gentleman, he is a Joint Secretary, Finance Department, MNF General Headquarters, Aizawl. So 11th September is after the last date is over, and he's a political personality. Then Lordship will kindly see page 26. On 13/9/2019, the office note says from the concerned Health Department official, if the Honorable Chief Minister and Health Minister desires the transfer as important and necessary, what could we say anything? Let us transfer
What
accordingly.
are we to say anything? But
And next page is the
Ms. Saikia, coming to the rules, whether the license is transferable.
no, it is not transferable. There's a specific bar also. Their own notification is there of 5th November 2019.
Yes, okay. Hmm,
5th November 2019 notification.
yes.
May I read it?
Hmm.
Circular regarding transfer of license. Location, premise, buildings are always inspected before getting a drug license.
Yes, obviously, that is.
It is
presumed.
not permitted to open drug license store apart from the location where the drug license allotted. It is not permissible to transfer drug license from one location to other location as per the Drugs and Cosmetic Acts 1940 and Rules 1945.
Okay.
Separate application with normal procedure should be applied if one desire to transfer license.
Hmm.
New location license application is not considerable just because license holder is willing to cancel the existing license in order to have a new drug license. Previous license will be cancelled if new license is granted. Any application for transfer of license be not received from the date of issue of this circular. So no, there is no scope for transfer.
Right. Okay, but now there are two bidders who have offered the same amount. Who will get it? In the comparative analysis, there are two bidders.
Whoever is valid, Lordship. My submission is that if I am a valid tenderer and even I am the highest valid tenderer,
No, there are two who have
there is a
offered
difference
47.
of 300 rupees.
Hmm?
The other one is at 47,300
We are 47,300.
and we are the other is 47,000 flat. Number two.
Okay.
So I am the highest valid tenderer.
And now let's see the rationale of the single bench order.
Yes,
Let's
single bench order, Lordship.
Hmm.
Paragraph 11, page 86. From the projections made by the petitioner, the issue to be considered is to whether the private respondent or any other bidder who did not have, Lordship, got it, please?
Hmm.
Yes. Who did not have a drug license for operation at Falcon can be considered to be an invalid bidder. From the comparative statements annexed to the affidavit in opposition of the respondent medical college, it can be seen that there were altogether 13 bidders for the pharmacy canteen at Falcon. Out of 13 bidders, 3 bids were found to be invalid, leaving only 10 valid bidders. Out of the 10 valid bidders, the petitioners was the only one to have drug license at Falcon at the operational area. In fact, it is not correct. There are 2.
Hmm.
Further, from a perusal of the terms and conditions which is annexed to the affidavit, it can be seen that the condition number 3 provides that the selected pharmacy canteen vendor must have a valid general drug license, Schedule H, and one Xerox copy of the license must be attached. Besides this, there is no stipulation anywhere in the terms and
All right, Mr. Yes, Mr. Das. Yeah,
Just-
absurd.
I'll just-
Absolutely. Trade in drugs cannot be beyond the area of the
I-
license.
No, I'll just.
Simple as that. Yes.
No, my lord, that's not simple. I'll just, great respect, I will just differ with this.
Yes,
62.
definitely.
Before that, I just want to point out.
What is this kind of leverage
No,
given to
that's-
one
that's-
person?
No, is
But
right.
all right, if the CM desires transfer the license,
My lord,
if he could have done business in the Falcon area on the existing license, just hold on, sir.
yes.
Then what was the need for transfer?
No, that's wrong. I'm saying that's wrong. But it has
Yes.
not been given to the private respondent, my lord. It has been stayed by this appellate body. And
Yes.
He's not, today, what is the effect? He
You're not
may,
bothered. If you had acted fairly, they would have got it.
no.
They would
that's-
have operated the
He will
canteen.
not get it by virtue of 62 also.
Why?
He will not, like, kindly see my lord 62.
Yes.
It is, my lord, there is.
Whosoever gets it, but it has to be strictly in compliance with the Drugs and Cosmetics Act
Kindly
and the
see
rules.
62. What
Yes.
is 62 says?
Let's see.
Kindly see 62.
Yes, please.
Sell at more than one place.
Hmm.
Lordship got it?
Hmm.
If drugs are sold or stocked
Hmm.
for sale at more than one place,
Hmm.
separate application shall be made and a separate license shall be issued.
Yes.
So, my lord, suppose I have a license here. It doesn't mean I cannot participate there
Hmm.
in a particular, let us say for an example, in a fancy bazaar area.
Hmm.
What I have to make, I have to make an application
Hmm.
and thereafter a separate license will be issued.
Hmm.
It is not a bar that a person holding a license here cannot
So you mean to say
participate
after
there.
getting the tender, after getting the order, he will have to apply a fresh license?
Right, my lord, that's what 62 says, my lord.
Hmm.
62 doesn't debar that a person, that is why, my lord, terms and condition makes it very clear.
Hmm.
Terms and the license says a general valid license.
Hmm.
So, my lord, suppose I am having a license here I may, 10 places I may apply, but I have to apply, make an
For a fresh
application.
license.
Fresh
for that particular
license.
place.
Can you see the wording? If drugs are sold or stocked for sale at more than one place, separate application shall be made and a separate license shall be issued in respect of each such place. So that is very clear, 62. Now, what is there? Let me put it very fairly to your lordship. It was not proper to issue to the private estate. It was not proper. I am stating at bar, it is not proper. My lord.
For the reason?
Reasons are how can it be given? Because his rate, suppose you consider the whole. Kindly see
The rates, there are other bidders who have high rates.
My lord, one lakh.
Yes.
62, my lord, I nullify the particular argument which is that was my lord.
So the highest offer has to be accepted.
This is, my lord, when this appeal was moved, kindly see, my learned friend, 2 appeals were moved. If you are so interested, the appeal which was moved and the stay which was granted in favor of the other party, which is 47,000. If my learned friend was so interested, he could have pointed out before the court that my rate is 47,300. Why don't you give it to me? He didn't say that. Appeal was listed together and the stay was granted. The learned division may say that it will operate to the lessee who was holding it. Earlier lessee. His rate was 47,000. My learned friend was 47,300. 2019. He readily, merrily accepted that. Why from 2019 till today, why he did not make any application saying that no, it should be modified to the extent that my rate is higher. He did not come to the court, and today, my lord, will see.
As on date, RZ Pharmacy is operating.
This is operating by the other party.
RZ Pharmacy 47,000.
47. My learned friend is 47,300.
Right.
2 appeals were moved together. Why my learned friend did not point it out before the court that my rate is 47,300?
Forget about that. Why
No, that's why. Now, my lord will kindly see this 62. Whoever has to make an application, separate license has to be issued. So my humble submission before your lordship is that let us retender it. The highest we have to earn also.
Yes.
Where is the question? Today is, my lord, we are suffering.
5 years down the line, yes.
Yes, that's my submission before lord. And secondly, my lord will kindly see the date of execution of the agreement. Kindly see 60. That's what my learned friend has pointed out.
Page
60.
60.
No, terms and condition which has been laid down is at page 62.
Just.
Page 62.
Yes.
Now kindly see number 5. The pharmacy canteen shall be rented for a period of 2 years. These terms shall be calculated from the date of agreement. So and so, management committee is signed, no person. So now your lordship will kindly see what is the date of agreement which was executed private respondent. At page 70, 75, kindly see, my lord. 74. Kindly see 74. This is the agreement which is executed. If your lordship kindly turn to 75, 70, this is 23rd of September 2019.
The agreement was already executed.
But he couldn't operate because there is an interim order passed. So what remains, my lord? He is not getting the benefit out of it, my lord. So our humble submission is that, my lord, let this go, my lord. Everyone will participate, my lord. There is no bar that somebody, another district cannot participate.
Right.
You have to apply a separate application. You have to get
After getting, one cannot get a license in anticipation.
correct. Right. That's what, my lord. It says.
So my submission is regarding the 2 years term, lordship. The terms and conditions very clearly says that it will start from the date of the agreement. The agreement.
Ms. Saikia, just let us know. If you go strictly by 62, where is your license? Let us see. Where is your license? Yes.
My license.
Let's see.
Yes.
That must be for a specific place.
Yes.
License is restricted to a particular premise.
Yes.
You're already having that. So how you will be able to operate in the canteen on the basis of that license? If your argument is to be accepted,
Yes.
you can't operate at any other place.
Lordship, can you see that?
There is one proviso in 62. Itinerant vendors who do not have a specific place.
Falcon area is there.
No, let us see. Can't be.
It is there. Lordship.
Let's see where is your license?
Yes, I'll place it.
Is it a part of record?
I'm just giving the other person's license, Lordship.
Just give us your license, sir. Everyone's
No, it
license.
will be in the same general format.
No, but it has to be the shop, the identification of the shop.
Yes,
has to be
I'll
there.
place it, Lordship, if it is not.
Take a time.
We have it.
Must be. As a matter of fact, it should have been filed on record. But we'll see it anyhow.
Because it was nobody's case that my license is not valid at
That's
any
not the
point of
question.
time.
If we go by interpretation of 62, Ms. Saikia, the
I'll place it.
license is
Yes.
specific
Page
for the.
42.
Eh?
Page
Yes.
42.
Yes.
Page 42,
Hmm.
Form 21C,
Hmm.
under Rule 2063.
There's a map which is required to be annexed. That map is not there. Premises situated at Falkwan.
Yes.
It can't be a random premise anywhere.
No, that
There
is-
is particular shop has to be identified.
This is as per the Drugs and Cosmetic Form
So
21C.
this is not the only thing. There has to be a map of the area shop.
Let them come and say
Hmm.
on affidavit that we do not fulfill and this license is.
Not that. The license must be accompanied with the map of the premise. So the licenses are always issued. We have dealt with a lot of cases of drugs.
Lordship.
Is always issued for the particular shop. As you said, excise vend. The shop has to be identified. It can't be that you give for a.
Site map is in the file.
Yes. So that can't
Without
be for
that,
the.
there are a lot of preconditions. Ultimately,
Yes,
this is issued.
Ms. Saikia,
Form 21 or
you
Form
understand, you will agree that the license can't be randomly for the entire area.
No, it is.
So Falkwan also you have to identify the particular shop.
Yes.
So if your argument goes, you can't trade beyond your shop.
I understand.
So if you are to get the canteen, you will have to get a fresh license for that canteen. That is what the argument which is coming is, and that seems logical.
No, we are on 2019 now, Lordship.
Hmm.
What is the position today? Definitely, if additional affidavit has to be filed, I will file it. Bringing all the validity about the present date. That is.
No, we'll see. We'll examine. Okay.
No, my case is not over till now.
Okay. Please carry on.
Now, the form is given in the Drugs and Cosmetic Rules 1945. Form 20 and Form 21.
Let's see. Form 21 page. Do you have the page of the book?
Yes.
Form 21.
Form 21C.
Just.
So my license is Form 21C. Yes. Page 255, Lordship is having the same book.
Yes.
Form 21C, I think it is.
255 years.
Let us read Form 20, Lordship. License to sell, stock, or exhibit or offer up for sale or distribute license by retailer other than those specified in Schedule C, C1 and X. I hereby license to sell, stock, and exhibit to offer up for sale by retail drugs other than those specified in Schedule so and so of the Drugs and Cosmetic Rules 1945, and to operate a pharmacy on the premises situated at, there is only one word.
Premises.
Subject to the conditions specified. So I would like to bring everything.
Premise has to be specified. in your
Yes, Lordship,
application.
now if the rules is there and this authority, the Deputy Director FND Mizoram, he issued this on 10th of February 2015. Page 42. It is issued by the government authority. I cannot add anything or subtract anything.
Hold on. Let's see your license once again. It is at page number
42.
42. So that was valid only up till 31st December.
It is all subsequently renewed. That is why
That's what we are
if Lordship wants to verify whether I have a valid license as on date
No,
or not.
valid license, it's no one's case that you didn't have the valid license.
That is
It
not,
should have
that
been
was not
valid.
the case.
It should have been valid on the date of the advertisement.
Exactly, on 23rd of
No
August
one's
2019.
case. Yes.
So on that day, it was valid. Till if Lordship wants to verify today also, I'm ready to place that record. So here it is the format. This is a general format.
Yes.
Whether it should be accompanied or attached with a site map or not, that is not required as per this thing. Because otherwise they would have said below enclosed the site map.
Very well.
Because in the record, they must have, otherwise this license is the final outcome of a detailed process.
Okay.
And on top of that, Lordship, what is the position they are doing? What Mizoram government is doing? The biggest pharmacy canteen is in Aizawl. Trial place. Their action, why they want to do retender here, and what they are doing in respect of the biggest pharmacy canteen in Mizoram. There are two. One is in Lungle, the other one is in Aizawl. In Lungle, Aizawl, they have renewed it from 2021 till 2025. 3 times they are giving extension. 1 year extension, 1 year extension. Now, finally on 23rd, in 2023, 1st April, they extended by another 2 years. They are not going for retender.
We are not concerned with that.
No, because their argument is that they want to do retender here.
So that argument is for a different reason. Mr. Das says, even the grant of tender to the private respondent.
I'm not
was
saying the
proper.
valid, who is having the valid license,
So that is
and who is the highest bidder.
the argument is by the learned Advocate General on the ground that even grant by the authorities to the private respondent was incorrect because a higher rate was offered by one more person. So otherwise also the grant to a person having offered 60,000 only was not correct.
He is 60. One was quoting 1 lakh.
1 lakh.
He is
So-
also not having a valid license. So he is
No one
gone.
says, it's no one's case
No one's case.
that he was not having a valid license.
No, here, Lordship, if you look at, because he is not before this honorable
That
court.
argument will deal, sir. We will deal with that argument. Not an issue at all.
So my humble submission is that the 2 years period will start once the valid agreement is executed,
All right.
not an agreement executed and invalid, or a person who does not deserve to be allotted the work. That agreement will not defend it or
Save his cause. As per you. Yes,
So this is my case, Lordship.
very well. You have to argue anything?
And Lordship, I have 2 judgments regarding that on the last date of validity, last date of submission, all the documents to be, and here also, the license has to be attached with the bid on 23rd. That is a condition in clause 3. A photocopy is to be attached. So he did not have that photocopy also or the license on 23rd of August.
The private respondent.
Private, no, the private, yes, Lordship. So he got it on 13th or 17th of September.
Yes.
So much later, because the terms and conditions, if I am allowed to place it once more,
Yes, sure.
page 62, clause number 3. The selected pharmacy canteen must have a valid general drug license, Schedule H. 1 Xerox copy of the drug license must be attached. So along with his bid, he must give that particular document also.
How do you say that it was not attached?
It was because he was not having it.
That is a subsequent license. That is an admitted case that he got it transferred later.
Yes, that means
No doubt.
he did not fulfill the terms and conditions regarding
argument-
eligibility on the relevant date.
That argument remains that on the last date of filing of the bid, he was not having
Yes.
the license as per you, which was required
Yes.
to
My
be
duty is
compliant of
to-
the.
My duty is that there should not be any confusion before this honorable court.
Yes.
That
Understood.
is my role. I've done my role. This is deeply obliged.
Yes. What right do you have to approach, gentlemen? Yes,
lord,
what is your cause?
Now, my lord, learned, my lord, senior advocate has filed one IA and alleging that I have not paid, my lord, the monthly rent, my lord. And in my reply, my lord, at page 30, my lord. There, my lord.
Reply to the IA.
Yes, my lord. IA 2214, my lord. Reply, my lord, at page 30, my lord. 30 and 31, my lord.
Yes.
And I have paid, my lord, till, my lord, 4/8/2023, my lord. And that hospital was, my lord, at page 26, my lord, annexure 1, my lord. On 27 March 2020, my lord, that hospital was designated a state referral hospital as COVID, my lord, 19 dedicated hospital, my lord. Therefore, sometimes they have relaxed, my lord.
Anyhow, that is a different matter. They want to recover, they will do it. That is their outlook.
And my lord, till finalization, my lord.
You
I
are
may
not
be-
in the running for the, so far as this bid aspect is concerned. You are running the canteen simply because you are holding the license earlier.
Yes.
That is the only reason. All right. Yes, Ms. Das.
Yes, no,
Anything
I-
to add?
Well, that's I argued, my lord. 62 is not applicable. Anyone can participate, my lord. But going there, you have to make a fresh application, a fresh license. And this period is over, my lord. So I humbly pray that is a retender so that everyone can participate. It gets a better rate to the government. Anyhow, we have not given to the private, there is an operation of the order where private respondent has not been allowed to run it also. I'm deeply obliged.
Arguments or judgment, sir. Through VC. Oh, so they must have joined.
But they were in the VC matter, but the mention was made for
Oh.
adjourned for 2 weeks. Madam.
So all right, if they have joined through VC,
Yes.
we'll record their presence.
Yes,
No, not
and we have filed affidavit also, madam.
all right.
Obliged.
Request was made by you,
I have.
Madam.
request-
What made the request?
Call for the affidavit in opposition filed by me, lordship, not for adjournment, lordship.
Okay, okay.
Deeply obliged, lordship.
Item 28.
Your lordships, my lord, we have filed an IA in the pending appeal against the orders of the learned single judge, that is page 22 to 25, 35. Lordship, earlier, my lord, the learned single judge passed an order in a writ petition bypassing 2 KVS. Thereafter, my lord, we filed a review petition that in spite of filing 2 KVS, we are not heard. But the learned single judge did not stay the order nor cancelled it, which is the settled position of law. If in violation of KVS, some order is passed, that is void ab initio. However, thereafter, being aggrieved, my lord, we have filed a writ appeal. And your lordship issued a notice. The lordship's order may kindly be seen, my lord, page 19, my lord. Page 19, it starts from page 20, my lord. Lordship issued notice and also simultaneously some interim protection was given, page 21, and registered judicial was asked to cause an inquiry how the KVS were bypassed. Now this matter was brought to the notice of the learned single judge on 19/7/2023, kindly see page 22, my lord. Operative portion, page 26. So we have brought the order of the appellate court before the notice of the learned single judge. Even the learned single judge did not state the writ petition nor the review petition. Now our apprehension is that, my lord, the matter is pending for disposal before this honorable high court in writ appeal. And if the simultaneously writ petition and the writ review petition is allowed to be continued, there may be problem of res judicata. So my humble submission is this, my lord, that lordship till the disposal of the writ appeal, the further proceeding of review petition, that lordship may kindly see page 12, review petition number 7623 and WPC number 317723 may kindly be stayed. That is only prayer. Otherwise, there will be res judicata, different orders may be passed by different courts which may create multiplicity of the cases for no legal reasons.
Who's there for the writ petitioners?
This is the first time, my lord, we have.
But then we let notice go. Notice of the IS to go.
But let us single judge is pursuing the
We have
matter.
already stayed, Mr. Member.
No, not state by law. That is so illiterable. That's some.
No, we have made it clear. As an interim measure, it is clarified that the appellant municipal board shall not be precluded from settling the market at any different location. So that liberty has been given to you.
That is given, but learned single judge is pursuing the order. Kindly see page 22, 26. Learned single judge, though matter was brought to the notice of the learned single judge, he continued the order, passing the order, said review petition as well as writ petition.
All right,
That
issue
is-
notice of the interim interlocutory application to the respondents. Service upon the respective departments be effected by providing copy to the standing council concerned. Requisites for effecting steps for effecting service on the response numbers 6, 7, and 8 be taken in 3 days. The file of WPC number
Page 12.
WPC number so and so and review petition number so and so shall be tagged with this appeal.
File.
rule is made returnable in 4 weeks.
All right.
Item number 30.
Yes.
I received it. Met with the lordship, this matter pertains to an industrial dispute. The appellant was a bank employee. And
Was
when
it?
he was dismissed, a reference was pending. So without taking approval as contemplated under section 33 2B, he was dismissed from service. This ground was taken. And thereafter, the reference award, an expertise award was passed. Though in this case, the management council appeared and at one point of time, and he has filed an application to the effect that the concerned workman is not a workman, he is a managerial
Bank manager.
staff.
Managerial post, how could the appellant have been treated as a workman? He was on the managerial post. So how he could be treated as a workman? That is right. That objection is absolutely justified. Satisfy us.
No, he was, according to them, he is in a managerial post. So, so the learned presiding officer was of the view whether he is a workman or not. That is a mixed question of fact. That has to be ascertained on the basis of the evidence.
Absolutely no, sir. Absolutely.
Evidence.
What is your pleading? What was your reply in the proceedings? Let us see. What did you say?
No, they have not filed the written statement.
You must have done it, sir. You must have filed something. You must have filed something in the tribunal. Let us see your pleading.
Page.
Where is the order dated 1/11/2008?
Order dated
1/11/2008. Your appointment order as a bank manager. Is it disputed?
This is the statement before the.
And it is a remand. Therein, these issues will be again considered. Why the order of remand is to be interfered?
It was a case, one aspect was not considered.
So, all right, let the labor court decide the issues in remand. What is the problem then?
One issue, that is whether a dispute was pending before the labor court.
Dispute
So
between
it was
whom, sir?
incumbent on the part of the.
If the concerned person is not a workman, how the labor could have had acquired jurisdiction to entertain the dispute? Tell us first. That is a fundamental, the basic issue which has to be considered for deciding jurisdiction. Where is your appointment order? We are asking you. We'll put the things to rest here only. If you are not satisfied with the remand, we'll close the things here, saying that you are not a workman.
Let him take it at 2 minutes.
This is not done, sir. All right, 2. Come at 2.
May I
Sure.
please- Yeah.
Yes.
My lord, I am for the caveat and we have not received a copy of the writ appeal.
A copy of the writ will be provided to learned counsel representing the caveator. Re-notify after 1 week.
Item number 31.
Yes, please.
In this, in this case, an industrial dispute was espoused by the workers of the NGC Limited.
Yes.
These oil sectors are not covered by the Minimum Wages Act.
And that is why, my lord, their minimum wage was not fixed under the Minimum Wages Act. And that accordingly, my lord, they have raised an industrial dispute for fixation of their wages, and that dispute was referred in the year 2008. During pendency of that dispute, my lord, another industrial dispute that was cropped up in the state of Gujarat, that was settled. And in terms of that settlement, my lord, this award was passed because the ONG authorities of the ONGC accepted that fair policy arrangement, my lord. Now, accordingly, my lord, this award was passed in terms of this. Now, my lord, so far this award is concerned, it is stated that the workmen concerned who were in service, that is not workmen, the contract laborers who were in the service till 1/4/2012, their case will also only be considered to take to bring them under the settlement. Otherwise, the person concerned will not be considered. Now, we had an occasion during the pendency of the industrial dispute, a large number of the contract laborers were disengaged. And that led us to file an application under Section 33A of the Industrial Disputes Act before the Labor Code. But the management wrote a letter that you can only accept this settlement if you withdraw all these pending cases. And that compelled us to withdraw this application under Section 33A, and we can leave to approach this matter to before the appropriate forum. Accordingly, my lord, we filed a writ application before this honorable court, my lord. This honorable court dismissed our writ application on the ground that your case is covered by a settlement.
Yes, your union has accepted the settlement.
We have accepted this. We have accepted this settlement.
Award,
so
yes.
you cannot approach this as the court. No, that is the basic content of the impugned order. But one thing is that this award is valid after 31st March of 2017. And thereafter, my lord, the award is valid up to 31st March 2017, or due issuance of any notification on the Minimum Wages Act. So our contention was that Section 25H of the Industrial Dispute Act inter alia stipulates that whenever a retrenched employees, whenever the employer proposes to engage an employee, he should give the preference to the retrenched employees. That was our contention. In order to fortify that our contention, we took a plea. You see, so for the principal employer is concerned, Section 2G of the Industrial Disputes Act, as well as the Section 2G of the Contract Labor Regulation Act, states that the institutional head will be the principal employer. So our case should be considered in that line. That was our contention before the single judge. At this stage, your lordship may kindly issue a rule. So we have not praised for any prayer for
Admission notice. Steps for service be taken in 3 days, whereafter process be issued.
Item number 32.
Then standing counsel submits that he has filed affidavit in opposition today. The same be brought on record. Re-notify after 4 weeks.
Item number 33.
Item 33, no one. Yes.
Your lordship, pleadings are completed. This case may be disposed of at the admission stage.
All right, we are disposing of. Say what is the PIL about?
Your lordship, this PIL about the fishes.
Fishes. All right. What is your argument after their affidavit? Yes. What do you have to say?
Your lordship, that's the only instruction I got from my senior. That's what.
What do you want today?
Your lordship, this case may be disposed of. Maybe disposed of. Your
Maybe disposed of, closed. All right, in view of the, and counsel for the appellant petitioner submits that in view of the averments made in the affidavit filed on behalf of the respondent, the state of Assam, and the assurances given therein to take care of the issues raised, to address the issues raised in this PIL, the matter may be closed, ordered accordingly.
Item number 34 to 36.
May I please, my lord? My lord, item number 34 to 36 are similar in nature. 36 may not be required to be considered. My lord, that can be closed. 36.
As stated, Mr. Nair, representing the petitioners in writ petition number 1570/2018, submits that there is no cause of grievance.
Because, my lord, this was prior to that publication of the 309 rule, my lord.
Submit
So,
that the
that is
cause of
covered in the-
grievance, no cause of grievance survives to the petitioners herein, and hence the petition may be closed, ordered accordingly. The 36 is closed.
It will be covered by 34, my lord. No.
And furthermore, his further submission is that the decision rendered in writ petition, batch of writ petitions led by 2763/2019 would cover the issues raised in this writ petition.
Lodge.
Accordingly. Okay. Now we are left with 34.
34 and 35.
35 is an IA
35
in a writ petition.
in a writ petition.
Okay. So,
My lord, the petitioners before my lord are working in the LP school as as teachers. And they have the
Mr. Advocate General was appearing on the last date.
last day. He
You will
was
be
supposed to-
appearing.
Yes, I will be.
All right.
Now, my lord, the 7 CPC accepted the recommendations were made. The pay scale of the LP school graduate teachers having graduate qualification and ME school teachers having graduate qualification, both were given the grade pay of 8,700. And my lord, the untrained undergraduate teachers were given 6,200. Accordingly, the recommendation was accepted by the government, and the government, my lord, published the ROP rules. By incorporating this, that my lord would find at page 23, my lord. My lord, this is the 2017 ROP of
Revision
the
of pay.
publication by the government.
Okay.
My lord would see the ME school in the top. Graduate teacher, it's my lord, earlier in the sixth pay commission, it was 5,200 to 20,200, 2,700. Now it is 14,000, 49,000, 8,700 grade pay. Now, my lord, junior undergraduate, they were having 2,500 grade pay earlier. Now they have been given 6,200. Now the LP school is just below, my lord. Graduate teacher here would be 2,700. And my lord, 8,700 is the present one. Undergraduate teacher, 6,200. Now what has happened, my lord? The authorities then sent this matter before the Anomaly committee. We didn't go. We were satisfied with this. And we were drawing our pace, my lord. The Anomaly committee, on consideration, my lord, reduced it in this manner, my lord. Page 25.
Okay.
Down below, my lord. Anomaly committee recommended the following. LP Junior Basic School trained graduate teachers from 8,700, they made it 7,400. And my lord, untrained graduate teachers from 6,200, they raised it to 6,800. Now in ME school, they maintained it, trained graduate at 8,700. And my lord, untrained graduate at 6,800. So my lord, untrained graduate teacher, untrained teachers raised from 6,200 to 800, maintaining parity with the ME school. Whereas for the graduate teachers, my lord, they have reduced it.
What is the rationale behind it?
Rationale behind it, my lord. But then that was accepted at page 28.
Amendment was made. That's why, my lord, I filed the writ petition. It has come up before your lordship.
Was any recovery directed?
No, the recovery was, my lord, there was no recovery made till now, but they were contemplating to make a recovery.
Because similar controversy arose in Rajasthan.
Rajasthan, my
The
lord.
notification was 30th October 2017.
Lordship.
So sitting division bench, it was directed state to reconsider everything.
Lordship. And they did it?
And they did it, the rationalization has been done.
Done, my lord.
So if you
Because
suggest,
my lord had proposed that, because
Yes.
here the decision is already taken, my lord.
no, then it was sent back.
Sent
Decision was taken even in Rajasthan.
Ah.
It was sent back to reconsider.
But here, my lord, they have, what they have done here, after the, my lord,
But
pay
in
commission
Rajasthan, the matters pertain to recoveries.
recovery.
That was not only for teachers,
For
for
all.
various services.
So here, my lord, recovery is yet not yet started.
Hmm.
Here, my lord, pay commission made a particular recommendation that was accepted by the government.
Hmm.
For around 18 months, we got it. In the meantime, this anomaly
Committee.
and the anomaly committee recommendations were, my lord, accepted the fact here, my lord. If there is a difference between the ME school and the LP school, that difference must be pervasive in all cadres, my lord. Here you are raising
Only
undergraduate
one cadre.
teachers to 6,800, whereas bringing us down, my lord.
Hmm.
Now, the rationale behind that, my lord would find at page 39 onwards, running page.
Hmm.
This is the pay commission, their affidavit, my lord, pay commission recommendation at page 39, 1.6 below, my lord.
Hmm.
The commission recommends that normal school and basic tenders should be amalgamated and teachers in fact be classified into two categories with graduate qualification and with undergraduate qualification. The teacher with graduate qualification be paid GP 3,300 and the teachers having undergraduate qualification be paid GP 2,500. The principals of this amalgamated insurance should be given 5,900. The commission recommends that in each of LP school, one of the post of graduate teacher be upgraded and redesignated as headmaster with GP of so and so. However, the incumbent of this post should be the senior most teacher in the school. Now, this is relevant. Well, let's see. The commission feels that at the level of ME, LP and ME schools, there is no justification for differentiating the qualification of science graduate with vis-a-vis arts graduate or any other graduate. Accordingly, the commission recommends that all the graduate teachers in LP and ME school should have the same GP of 3,300, which corresponds to 8,700, my lord. It is therefore recommended that all teachers who have undergraduate qualification should be put at rupees 2,500. Now the anomaly committee's report is at page 11. Sorry, my lord, 41.
No, but this doesn't talk of untrained teachers and everything.
No, the undergraduate, my lord, it says undergraduate qualifications.
But untrained teachers, that was the category.
Lordship,
that
this
category, doesn't talk of the untrained teachers.
This doesn't talk, but it was put in the categorization that was made, my lord. It was, my lord, graduate teachers. My lord would have that.
You have that very grievance. Untrained teachers being brought higher. So where is the recommendation?
My lord, the recommendation acceptance is at page 23. Therein, my lord, we'll see the categories: graduate teacher, undergraduate teacher.
This is the anomaly committee.
No, this is the pay commission, my lord.
So that's what we are asking. Where is the recommendation of the anomaly committee?
That my lord would find at the next page, my lord, 41.
So this at 39, what
that
you
is
were reading,
pay commission.
Pay commission.
Pay commission's recommendation.
Okay.
Pay commission, graduate, undergraduate. Now, my lord, will come to page 41.
Yes.
My lord would see how it went there. The finance PRO department has referred the matter relating to pay fixation of teachers of lower primary and upper primary school to anomaly committee. In this connection, the committee examined the recommendation of the 7th Pay and Productive Pay Commission contained in so and so. The commission feels that the level of LP and ME schools, there is no justification for differentiating the qualification of science graduate vis-a-vis arts graduate or any other graduate. Accordingly, the commission recommends that the entire graduate teachers in LP and ME schools should have the same GP. It is further recommended that all teachers who have undergraduate qualification should be put in GP of rupees so and so. In the above recommendation, the 7th so and so mentioned that there is no justification of differentiating the qualification of science graduate vis-a-vis arts graduate.
Your grievance is you're scaling down from 8700 to 7400.
And my lord would see an anomaly committee is basically set up for the employees. After the government accepts the recommendation, if there is something, we go there. Here, my lord, the finance department is going.
Where is that discussion regarding you bringing down the trained graduate teachers from?
Lordship, my lord would have it in the third paragraph, but
the fact is.
the fact is that in the case of LP and junior basic school, there are no science, arts or any other graduate posts. These category of posts exist only in ME schools. The committee examined the minimum entry qualification required for various categories of posts of teachers as per existing applicable service rule. The minimum qualification for teachers in LP school is undergraduate. Therefore, the scale of the pay of graduate teachers is prescribed is not justified in case of teachers of LP school. The Anomaly committee carefully scrutinized the recommendation made by the previous Pay Commission, and it was found that the ROP rules of 1990-1998, there were two categories of pay scale for LP school teachers, that is trained teacher and untrained teacher. But under the ROP 2010, the LP school teachers have been declassified under three categories: trained graduate, trained undergraduate, and untrained teachers. The pay scale of these teachers were recommended in the same pay band, but with different grade pays. That is rupees 2,700 for trained graduate, 2,500 for the two other categories. Therefore, Anomaly committee is of the view that there should be different grade pay for different categories of LP school teachers in accordance with the ROP rules of 2010. After careful consideration, the committee recommends grade pay of rupees 7,400 for trained graduate teachers, 6,800 for untrained graduate teachers, including trained undergraduate teachers, and 6,200 for untrained teachers under the ROP rules. Then my lord would have the next paragraph. In case of ME school, ME and other upper primary school, the Anomaly committee feels that there should be parity of pay scale amongst all teachers, irrespective of streams, arts, science, commerce. Therefore, the Anomaly committee recommends grade pay of rupees 8,700 to trained graduate teachers as applicable to science graduate teachers. The committee also recommends grade pay of rupees 6,800 to untrained graduate teachers, including trained undergraduate and untrained graduate teachers. The remaining teachers without training shall continue to get grade pay of rupees 6,200. But the interesting factor here is, my lord, in the ME school, there was only one post of graduate teacher getting graduate scale, that is a science post. He teaches science subjects or maths, my lord. The others were not brought. The art subjects were not brought within that graduate cadre. From 2010 onwards, my lord, they were subsequently said that all should get it. In 2017 ROP, it was made applicable to all, irrespective of the fact whether the post is a graduate post or not. If the person is a graduate, he gets that scale of pay. Similarly, my lord would see the untrained graduate teachers, they are given 6,800 in both the schools.
Both the schools.
And 8,700 was accepted by you, paid. And thereafter, you went to the Anomaly committee, which is normally not the, my lord.
So what is the process of the consideration by the Anomaly committee?
Anomaly committee,
whether the employees association are heard?
The employees association has to go. And
no, are they heard? Supposing
no, we were not heard. It's our association were not heard. Some other associations had gone on different points. On those points, they were heard. But for this, my lord would see how it had come from page 41, the first line itself.
Finance PRU department has it.
Finance PRU department has it.
What do you say? Those who have been affected adversely after having been given a higher pay scale, reduction brought around, they were not heard.
Here, my lord, so far as the present issue is concerned, it is the finance department who moved the Anomaly committee.
And those who were likely to be affected by this, why they were not heard? You had paid them 8,700.
Then
one fine evening, you decide on the recommendation of finance department to bring them down. So why their representation was not?
Well, that part, of course, is not reflected in the Anomaly committee.
It's not there. It's not there. Then,
in that regard, I will have to have the specific instruction because the Anomaly committee is as on date, it is not there. Whatever is there in the main final report, I can.
We understand. But in this process,
yes,
if at all,
but
you are trying to reduce the pay scale which was being offered,
my lord,
which had been given, approved by you, then you want to retrace your steps. Then the adversely affected people, they have a right to be heard.
On Article 40, on that point, my lord, of course, I will have the instruction. Otherwise, the fact is, my lord, the petitioners herein, my lord, their substantive post is, my lord, it is an intermediate post. And their minimum qualification is only high secondary.
Graduate.
No.
No, we are having graduates.
They have the qualification, but the minimum qualification for that particular post is only, my lord, class 12 pass.
We understand.
Just because, my lord,
that is so for the untrained graduate teacher also. You bring the untrained graduate teachers to 6,800 in both categories, LP junior and ME basic. for them, you are bringing them up. And you are bringing now the trained graduate teachers.
But they
From-
are getting higher than those, my lord, untrained. At least 7,400, the present petitioners are getting.
What
less on
about
that.
in ME? What is the qualification of a trained graduate teacher?
Trained graduate, it is graduation, my lord.
Graduation,
Yes.
ME.
Yes, my lord. The
Mr.
mode
Nair?
of recruitment is totally different, my lord. My lord, regarding.
Mr. Nair, what is the qualification in
My
ME?
lord, for in the there, it's only one post which is my lord graduate. The other posts were my lord undergraduate.
All other posts?
All other posts, because there was only one post of science graduate teacher.
Okay.
Others may have that qualification, my lord.
Having is a different thing.
Different.
What is the requirement in the rules?
Requirement is under intermediate post, my lord.
Then how do you distinguish between ME teachers and LPT?
My lord, that part, my lord, regarding the qualification, my learned friend from the education.
Hey, Ms. Mazumdar will say.
My lord, I have filed an affidavit.
When? Ms. Mazumdar, issue is that you have reduced their pay scale.
No,
No,
reduction is from the finance.
We understand.
By the rules.
But in that anomaly committee, which took up the issue on the request of the finance department, the likely to be affected employees were never given an opportunity. So it is unilateral action of reducing pay scale, which was given after 1.5 years, 18 months. Were they not required to be heard?
Issue is the finance has taken the graduation trained teachers, trained graduate teachers.
Understood.
If a teacher is not graduate, per the very
Same
entry
situation
level,
in ME schools, other than science, all other streams, higher secondary is the qualification.
Yes.
So why they are getting 8700?
my lord, that is a subject matter of another repetition, my lord, where we have withdrawn, we are saying that they were not entitled to get it.
But then you are giving as on date, it's your
That was
recommendation.
given at the district level, my lord, not by the directorate level. It
Irrespective,
was,
this communication which is there on record, approval of the state government, it says ME, MV senior basic school. Earlier, there was a distinction between science. Only science teacher is required to be a graduate.
yes.
The others are required to be higher secondary.
Graduate.
So if you are giving them 8700, why in LP you have reduced on this logic that they are undergraduates?
The second, the trained graduate teacher just below them is untrained graduate teacher, including trained undergraduate teacher and
So
untrained.
you have brought them up to
Undergraduate.
6600. Forget about it. They are not worried about that.
They are originally in that scale itself. my lord.
Who?
The persons who are serving in LP and ME schools,
Yes.
they were never required to be graduate at any point of time.
Understood.
So they could never be trained graduate.
Why not? Do you yourself kept that category here?
The definition of a graduate teacher is given in
What is a trained graduate teacher?
my lord, yes, the rules if lordship will have to.
Let's see. What is a trained graduate teacher?
Since my lord, the elementary education never had
Do
graduation.
the rules provide different categories or definitions
Yes,
of a trained graduate teacher and
yes.
an untrained graduate teacher?
Yes, my lord. Lordship will have the rule 2000, rules of 2003.
Read.
2003 rules.
Mr. Mazumdar,
My lord, yes.
the only logic in your discussion in the anomaly committee is that these people are having higher secondary qualification, right?
Yes,
In the ME,
yes.
but the same is the situation in the LP. Same is the situation in ME, other than science graduates,
No.
others are science teachers, others are all
All.
higher secondary qualifications.
Yes.
Then how can you distinguish between the two?
No. Lordship will kindly have page 365 of this book.
Mhm. Yes.
Yes, because in elementary schools, there was never any provision for a graduate teacher. There will be no definition. The only definition we find is in the rule.
365.
365 Lordship will find.
Yes.
This is part of definition, clause 2N.
Mhm.
Graduate teacher means category assistant teacher in higher secondary and multipurpose higher madrasa schools for whose appointment the minimum qualification prescribed is a graduate degree in arts,
Mhm.
science or commerce, including demonstrations in so and so, which shall also include so and so. So once a person is coming into a school with a graduation as the minimum qualification, then Lordship will have kindly clause O.
Mhm.
Junior teacher means an undergraduate intermediate teacher.
Mhm.
So the two qualifications are totally different. Someone comes in with an intermediate degree, intermediate qualification, someone comes in with a graduate degree.
Mhm.
Now, like in the elementary schools, I have given the chart in the affidavit in opposition. Never was the case that there was any teacher accommodated in an elementary school except the science graduate teacher with graduation degree. It was always intermediate degree, so we never had graduate teachers.
Understood, Mr. Mazumdar. The issue which is troubling us is that when you consider in ME schools, trained graduate teacher, other than science, the other categories, other streams, all teachers are intermediate. So then if you are giving all of them uniformly 8700, you could have made a distinction. Here in science graduate, 8700, others 740. They could not have any
petition pending, Sinha, where we have not given her the pay scale. We said this is wrongly, this is wrong, you will not get it.
withdraw it.
My lord?
Withdraw it then they would not have any grievance.
When we
Their
did-
grievance is
that is what I'm
Article
saying, we
14.
did not give it. We did not give it. They approached this honorable court.
We
in
have
a
given it
petition.
here.
That is what I'm saying. But in some of the districts at district level, simply taking the person's graduation certificate, these
Is this-
inspectors allowed it. We are not, we had, the
Is
department
this
has
a
not given it.
recommendation of a district? This is not a recommendation of the
Not
district.
the reg- not-
This is your pay commission.
Per the pay commission's recommendation at the district level, the district officers made a mistake and anyone who had a graduate degree but was an intermediate teacher was paid. That was caught.
Mr. Mazumdar, you are
That was
not
detected.
getting us. We are asking a simple question. There are two teachers having intermediate degrees.
Yes.
One is working in the ME school, one is working in the LP school.
Yes.
How can you give them different pay scales?
We are not giving them different pay scales. That is what-
Come to page 25, please.
Four LP, no, Bele Casa Association.
Page 25.
LP school is trained graduate teacher 7,400.
Yes. An ME school trained graduate teacher, 8700.
As applicable to science graduate.
This is
My lord,
7,000.
my friend's argument, my lord, page 28. It's the government who has accepted this, my lord. Now, how can he say that we are not going to give it? It's a notification under 309, my lord. The anomaly committee's thing was accepted.
And where is the decision to recall this? This 4th August 2018?
No,
Whether it
there
has
is no
been recalled.
decision. This is what is under challenge before my lord.
This is under challenge.
Because this is after the anomaly committee's recommendation, they have amended.
Okay, okay.
They have amended the ROP rules, my lord. Saying that ME will be 8,700, LP at page 29 would be.
How do you explain? Tell us.
Just to be explained by the finance department, but our stand remains that in.
Your
LP
friend,
and
you are making a distinction between teachers having graduate degree as a qualification in your rules and teachers having intermediate as a qualification in the rule for being appointed.
Yes.
That is the basics of
Yes,
distinction.
yes.
Now tell us, in ME schools, other than science stream, the other streams, other subjects, teachers are qualified, required to be having intermediate. So if they get it 700, why in LP school, the same category gets 740?
That is what I was saying, that in Vinodini Sinha's case, which is in an appeal before this honorable court, the stand of the petitioners is that ME school teachers, this 8700 is not being given to those LP teachers. That is their stand. We are not giving it to them. In some districts,
Oh, gentlemen, this is a notification of the state.
they do not have a trained graduate teacher, my lord, in their school. An LP school cannot have it.
Then why do you give that pay scale in this?
We have not given it, and that is also the challenge before this honorable court is what I'm saying, my lord.
All ME schools are getting this 8,700.
What I'm saying is, my lord,
ME
teachers are
schools,
before this.
how can you give a, how can you pay a person contrary to this one? Tell us.
Because in that ME school, except the science graduate teacher, there is no other graduate teacher. He will get 8,700, not the rest of them. The others will only get 7,400. And because we have not given.
Bring out the pay slips then. Bring out the pay slip.
Lordship will do that.
All right. Mr. Mazumdar submits that even in the ME schools, teachers other than the science graduate teachers who are having graduate degree as a qualification, are being paid at grade pay of rupees 7,400 only. He shall keep the.
My lord, what I'm saying is that in some of the districts, they have been paid 8,700 due to the mistake of the district authorities. Our directorate or the government is not giving that.
Mr. Mazumdar, you say that this distinction, if at all your argument is
My lord.
acceptable, this distinction should be visible in this notification. This notification doesn't distinguish.
The notification never says that there is a post of a trained graduate teacher in a ME school. Save and except the science graduate teacher. There is no other teacher.
Gentlemen, read remarks column, please. Irrespective of arts, science,
And commerce. If there was an arts, science or commerce teacher, they would be entitled to this scale. Except for science, there is no other graduate teacher incorporated in the finance department has given a class. We do not have a teacher of that class. We do not have an arts or a commerce graduate in our schools, in our LP or ME schools.
My lord will ask them to bring those pay slips
Bring
of
the
the ME school teachers.
And Lordship will kindly ask them if any arts or commerce teacher is getting such a fee. If they can point out any arts or commerce graduate.
Well, if they get those the ME school, my lord,
There's no
otherwise,
arts or
my lord, they will have to show under what scale of pay the other teachers are getting. Because undergraduate, trained graduate, untrained graduate, and untrained teacher. These are the only three categories under which payment can be made. So they'll have to show under which category the other graduate teachers having qualification of graduation, other than the science, is being paid. If my lord, they can satisfy your lordship that they are being paid 7,400. I'll be withdrawing this writ application.
Now, list on 25th, he shall keep the relevant pay slips available for the court's perusal on the next
Will
day.
give me a little more time, my lord.
List on
28.
28
Lordship.
or 29,
Lordship.
29.
Lordship.
Supplementary list, item 39 to 41, part-third method.
I concluded, Mr. Nair was on legs last time and the.
Advocate General is supposed to be here.
My lord, yes, Your Honor.
One of them. Education. My lord, I'll place that TM Pies case, my lord, wherein the control 2002 8 SSC,
2002 volume
8 SSC 481.
It's like, yeah. You've gone through these provisions. So find them to be logical.
Their case absolutely against the principles laid down by the Constitution as well as various judgments of the Honorable Supreme Court.
Very well.
I'll place my case, Lordship.
Okay. Don't you find many discrepancies in your own rules? Significant discrepancies.
Their basic case is that we do not have the legislative competence. That is number one.
Yes.
And raised lordship, they are saying that there is a conflict with the central legislation.
That is the
That is their two grounds. One is the competence. I'll satisfy this honorable court. And the other part is lordship. They are saying that we have to take presidential assent under Article 254(2).
254(2).
Let them first place the law which is governing their case. That we have to compare the state law with the central law. Which is that central law? Let them place it.
Right. We'll ask.
My lord, one factor which my friend has missed out. What I am saying is, my right under 19(1)(g) to operate, establish and operate a private unaided institution, my lord, cannot be curtailed under 19(2) by bringing in these restrictions.
Yes.
It is in the teeth of TM5.
Let's read.
This is my case, my lord.
Let's
If my lord have TM5, page 529, my lord, paragraph 2. What is the challenge before the my lord? The court. It is in this scenario where there is a lack of quality education and adequate number of schools and colleges that private educational institutions have been established by educationists, philanthropists, and religious and linguistic minorities. Their grievance is that unnecessary and unproductive load on their back in the form of governmental control by way of rules and regulation has thwarted the process of quality education. It is their contention that the government must get off their back and that they should be allowed to provide quality education uninterrupted by unnecessary rules and regulation laid down by the bureaucracy for its own self-importance. The private educational institutions, both aided and unaided, established by minorities and non-minorities, in their desire to break free of the unnecessary shackles put on their functioning as modern educational institutions and seeking to impart quality education for the benefit of the community for whom they were established and others, have filed the present writ petitions and appeal, asserting their right to establish and administer educational institution of their choice, unhampered by rules and regulation that unnecessarily impinge upon their autonomy. Now, my lord, the rest is, my lord, with regard to the fact where it is placed and all. I'll not trouble my lord. My lord will come straight to 18, my lord.
Para 18.
Para 18 at 533. The issue is, my lord, is there a fundamental right to set up an educational institution, and if so, under which provision? With regard to the establishment of educational institutions, 3 articles of the Constitution come into play. Article 19(1)(g) gives the right to all citizens to practice any profession or to carry on any occupation, trade or business. This right is subject to restrictions that may be placed under Article 19(6). Article 26 gives right to every religious denomination to establish and maintain an institution for a religious purpose, which would include an educational institution. Article 19(1)(g) and Article 26 therefore confer rights on all citizens and religious denominations to establish and maintain educational institutions. There are no serious disputes that majority community as well as linguistic and religious minority would have a right under Article 1(g), 19(1)(g) and 26 to establish educational institution. In addition, Article 30 in no certain terms gives the right to religious and linguistic minorities to establish and administer educational institution of their choice. We will first consider the right to establish and administer an educational institution under 19(1)(g) of the Constitution and deal with the right to establish educational institutions under Article 26 and 30 in the next part of the judgment while considering the rights of the minority. Now, this is, my lord, the majority community. Article 19(1)(g) employs 4 expressions: profession, occupation, trade, and business. Their fields may overlap, but each of them does have a content of its own. Education is per se regarded as an activity that is charitable in nature. Education has so far not been regarded as a trade or business where profit is motive. Even if there is any doubt about whether education is a profession or not, it does not appear that education will fall within the meaning of the expression occupation. Article 19(1)(g) uses 4 expressions so as to cover all activities of a citizen in respect of which income or profit is generated and which can consequently be regulated under Article 19(6). Then, my lord, it goes on to discuss the various provisions of word occupation. I'm not troubling your lordship with that. My lord may come to para 24. While the conclusion that occupation comprehends the establishment of educational institution is correct, the proviso in the aforesaid observation to the effect that it is so provided, no recognition is sought from the state or affiliation from university concerned, is with utmost respect erroneous. This is with regard to that Uni Krishnan's case, madam, because saying it was bad. The fundamental right to establish an educational institute cannot be confused with the right to ask for recognition or affiliation. For the exercise of a fundamental right may be controlled in a variety of ways. For example, the right to carry on a business does not entail the right to carry on a business at a particular place. The right to carry on business may be subject to licensing laws so that a denial of license prevents a person from carrying on that particular business. The question of whether there is a particular right or not cannot be dependent upon whether it can be made subject matter of control. The establishment and running of educational institutions where a large number of persons are employed as teachers or administrative staff and an activity is carried on that results in the imparting of knowledge to students must necessarily be regarded as an occupation, even if there is no element of profit generation. It is difficult to comprehend that education per se will not fall under any of the 4 expressions in Article 19(1)(g). Occupation would be an activity of a person undertaken as a means of livelihood or a mission in life. Therefore, the above quoted observation in so and so correctly interpreted the expression occupation in 19(1)(g). The right to establish and maintain education institution may also be sourced to Article 26(a), which grants in positive term the right to carry right to every religious denomination or any section thereof to establish and maintain institution for religious and charitable purposes subject to public order, morality and health. Education is a recognized head of charity. Therefore, religious denominations or sections thereof which do not fall within the special categories carved out in so and so have the right to establish and maintain religious and educational institutions. This would allow members belonging to any religious denomination, including the majority religious community, to set up educational living. Given this phrase, private education institution as used in this judgment would include not only those education institutions set up by secular persons or bodies, but also in education institutions set up by religious denomination. The word private is used in contradiction to government institutions. Now, my lord, after discussing whether, my lord, unification requires a consideration, my lord, we have para 29, my lord. This, my lord, I'll show that how the control is to be made. Reliance was placed on a decision of this court in Bangalore Water Supply and Severages Board versus so and so, when it has been held that educational institutions would come within the expression industry in the Industrial Dispute Act, and therefore education would come under Article 19(1)(g). But the applicability of this distinction was distinguished by so and so, that observing that we do not think the said observation is in a different context has any application here. While holding on an interpretation of Article 21, 41, 45 and 46 that a citizen who has not completed age of 14 years had a right to free education, it was held that a right was not available to citizens who were beyond the age of 14 years. It was further held that private education institutions merely supplemented the effort of the state in educating the people. No private educational institution could survive or subsist without recognition and or affiliation granted by bodies that were authorities of the state. In such a situation, the court held that it was obligatory upon the authority granting regulation and affiliation to insist upon such conditions as were appropriate to ensure not only an education of requisite standard, but also fairness and equivalent treatment in matters of admission of students. The court then formulated a scheme. My lord, this is with regard to that, my lord, can just, that unification, my lord. Now, my lord would have para 36, my lord. The private unaided educational institutions impart education, and that cannot be a reason to take away their choice in matters inter alia on selection of students and fixation of fees. Affiliation and recognition has to be available to every institution that fulfills the condition for grant of such affiliation and recognition. The private institutions are right in submitting that it is not open to the court to insist that statutory authority should impose the terms of a scheme as a condition of grant of affiliation or recognition that completely destroys the institutional autonomy and the very objective of establishment of a school. Then, my lord, the conclusion, my lord, would find my lord would have 53 and finally 61 and 66, my lord. With regard to the core 53, with regard to the core components of rights under Article 19 and Article 26A, it must be held that while the state has the right to prescribe qualifications necessary for admission, private unaided colleges have the right to admit students of their choice, subject to an objective and rational procedure of selection and compliance with condition, if any, requiring admission of a small percentage of students belonging to weaker sections of the society by granting them free ships and schools. This has now been taken over by the RTE, if not granted by the government. Furthermore, in setting up reasonable fee structure, the element of profiteering is not to be accepted in Indian condition. The fee structure has to be taken into consideration the need to generate funds to be utilized for better and growth of educational institution, the betterment of education in that institution, and to provide facilities for the benefit of students. In any event, a private institution will have the right to constitute its own governing body, for which qualifications may be prescribed by the state or the university concerned. It will, however, be objectionable if the state retains the power to nominate specific individuals on the governing body. Nomination by state, which would be on political basis, would be an inhibiting factor for private sector to embark upon occupation of establishing and administrating so and so. For the same reason, nomination of teachers either directly by the department or through a service commission may be unreasonable inroad and unreasonable restriction on the autonomy of the private unaided medical institutions. My lord would have 55.
54, read
54. The right to establish an educational institution can be regulated, but such regulatory measures must, in general, be to ensure the maintenance
No,
of.
you have to satisfy Mr. Nair
Here,
that
this
these
I'm satisfying.
rules are not within the domain of these observations.
I will satisfy that. Yeah.
Read, please.
The right to establish an educational institution can be regulated, but such regulatory must be in general to ensure maintenance of proper academic standards, atmosphere, infrastructure, and the prevention of maladministration by those in charge of management. The fixing of rigid fee structure, dictating the formation of composition of governing body, compulsory nomination of teachers and staff for appointment, or nominating students for admission would be unacceptable restrictions. Now, my lord, if I may just pause for here, these are being done in a regular manner by the authorities under the state. Under two different, my lord, in the state, we have two different acts. One is the Assam Secondary Education Act, and the other one is the Assam Higher Secondary Education Act, wherein, my lord, the SEVA, the Matriculation Board, and the Education Council, which gives the HS
recognition.
And in that, my lord, a power has been given to these two bodies to frame regulations. And in that regulation, they have, which have been framed, all these aspects have been covered. Now, my lord, the Constitution recognizes the right of an individual. This is with regard to, my lord, that minority. My lord will have 61. In the case of unaided private school, maximum autonomy has to be with the management with regard to administration, including the right of appointment, disciplinary powers, admission of students, and fees to be charged. At the school level, it is not possible to grant admission on the basis of merit. It is no secret that examination results at all levels of unaided private schools, notwithstanding the stringent regulations of the governmental authorities, are far superior to the results of the government-maintained schools. There is no compulsion on students to attend private schools. The rush for admission is occasioned by the standards maintained in such schools and recognition of the fact that state-run schools do not provide the same standards of education. The state says that it has no funds to establish such institutions at the same level of excellence as private schools. But by curtailing the income of such private schools, it disables those schools from affording the best facilities because of lack of funds. If this lowering of standards from excellence to a level of mediocrity is to be avoided, the state has to provide the difference, which therefore brings us back to the vicious circle, to the original problem, that is lack of state funds. The solution would appear to lie in the states not using the sandy resource to prop up institutions that are able to otherwise maintain themselves out of the fees charged, but in improving the facilities and infrastructure of the state-run schools and subsidizing the fees payable by the students therein. It is in the interest of the general public that more good quality schools are established. Autonomy and non-regulation of school administration in the right of appointment, admission of students, and fees to be charged will ensure that more such institutions are established. The fear is that if a private school is allowed to charge fees commensurate to the fees affordable, the degrees would be purchasable is an unfounded one, since the standard of education can be and are controlled through regulation relating to recognition, affiliation, and common findings, which is by the affiliating bodies. Now, my lord, the final conclusion at 66. Who will have that control, my lord? In the case of private unaided educational institution, the authority granting recognition or affiliation can certainly lay down conditions for the grant of recognition or affiliation. Those conditions must pertain broadly to academic and educational matters and welfare of students and teachers. But how the private aided institutions should run is a matter of administration to be taken care of by the management of those institutions. Now, my lord would have the two acts of the state. Education.
Yes.
My lord, the first one is at page 335.
Yes.
My lord, this is called the Assam Secondary Education Act of 1961. The my lord would have it come. My lord would have 338. My lord, why this act? The preamble. Whereas it is expedient to establish a board of secondary education to regulate, supervise, and develop the system of secondary education in the state of Assam. Now, the powers, my lord would find at page 345, section 13. My lord has got section 13. My lord, I'll have my lord's attention at Roman 9. 13, Roman 9, my lord. To lay down the conditions for recognition of high schools, high madras, and higher secondary schools. Then, my lord, 10, to recognize high schools, higher secondary schools, and high madras, and to withdraw such recognition. To take such disciplinary action as it thinks fit against institutions as prescribed by regulation. Then, my lord, 14, my lord, to prescribe necessary qualification of teachers in recognized schools. Now, the government, how it can act through these boards, that is, my lord, 14. Notwithstanding anything contained in this act, the board, state government shall have the right to address the board with reference to anything conducted or done by the board and to communicate its views on any matter with which the board is concerned. Then, my lord, the state government may, after consultation with the board, issue such directions consistent with the provisions of this act as it may think fit, and the board shall comply with such directions. The state government may, by order writing, specify the reasons therefor, suspend the execution of any resolution or order of the board, and prohibit the doing of any act ordered to be done by the board if the act government is of the opinion that such resolution, order, or act is in excess of the powers conferred by the so-and-so board or by under this act. So, my lord, similarly, it's with regard to the education, higher education institution also, it's covered by the Higher Education Act. Now, these two acts, the government through an agency is controlling. No school can operate, my lord, without being recognized by this board. And, my lord, there will be small books in the paper book, my lord. Small books would be there. Wherein, my lord, small books to this extent, my lord. It was given during the hearings, my lord. Asani. My lord, I'll just place, I'll just place that.
What do you want to read?
My lord, I only want to show that under this act, the boards, both the boards, have frame regulation, which, my lord, covers every aspect which, my lord, is read in paragraph 53. Just to that extent, my lord.
Yes,
yes. My lord, the first one is the Board of Secondary Education Assam, regulation or recognition of high schools, high madrasas. My lord would have it. It's, my lord, the first page opening. In exercise of powers conferred under section 24(1) and 2 of the Assam Secondary Education Act, so and so, as amended from time to time, the Board of Secondary Education Assam makes the following regulations. Now, my lord would come to page 4. The classrooms size, area, all have been prescribed. Then, my lord, at page 7, my lord would find the qualification required of teachers. Then 8.1, my lord would find the workload. And a BSc teacher, what combinations he should have, so that all the subjects of BSc, all the science subjects can be taught. And accordingly, my lord, if my lord proceeds further, the procedure for granting regulation, provisional regulation, provisional recognition, withdrawal thereof, then permanent recognition, everything has been, my lord, been framed by the government, basically. Then, my lord, the other one, it's called the Higher Secondary Schools and Junior Colleges Revised Regulation on Recognition 2004. This is under the Assam Higher Secondary Education Act. Here, my lord, similarly, my lord would find Yes. My lord, page 18, the requirement of land. 19 onwards, my lord. Then 22 and page 23, my lord would find the qualifications of the teachers.
The only opening part which probably you would be referring to in the Act of 2006 is the management committee.
Management committee, the unbridled power given to the director, which is not channelized. There is no check and balance. He can, my lord, have shown 14. 14 says that a scheme, even if that, my lord, now is being taken over by the fee committee acts under the act. But my lord, therein they say, I cannot increase. But if I satisfy the director, I can increase it. But where is the check and balances, my lord? And what was the need for that when the state has been, my lord, controlling these institutions? 2-3 boards. CBSE, my friend, has raised an objection which my senior, my lord, had dealt with. My lord, he can again address your lordship on that. That is under Article 13, a law. CBSE, that provisions and regulation have to be deemed to be a law existing prior to the, my lord, independence. It's there. So, my lord, it's a safe law. If that is a law and these are in conflict with that, then 254(1) would come into being. It is in that direction, my lord, we were trying to develop. And my lord, it also says it includes bylaws. And this is a bylaw by a body created by the central government Ministry of Human Affairs. But it's a society, my lord, otherwise. It's a society. Controlled by the Ministry of Education, Human Resources. Human Resources. Yes. This is my humble submission.
Yes.
And my lord, that bylaw need not come through a parliamentary act, my lord, for being in the provisions of 13, my lord, Article 13. Article 13. My lord, 13, 3A says, in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. Laws in force, passed or made by a legislature or other competent authority in the territory before the commencement of the constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be in operation either at all or in particular areas. Here, my lord, the regulations of CBSE, earlier it was, my lord, I think it was confined to somewhere in Madhya Pradesh, Bhopal area. Thereafter, my lord, it was expanded to all over the country and even outside. So, my lord, that's a bylaw. It's a law which was having the force of law. Because a school violating that bylaw, my lord, would have to suffer the consequences.
Yes.
Much obliged.
Anyone else wants to? Okay.
First, let us take the act. What is the intention of the legislature, Lord? And which provision is actually troubling them?
No. They are troubled by the entire act.
Entire act.
They say that you have got a measure of regulation already provided.
Yes.
Under the 2 acts.
Yes.
So what is the need for this one? And of course, the argument regarding contravening the intent and ratio of TMFI.
Yes.
Yes.
Now, this act is, Lordship, very clearly says the Assam Non-Government Educational Institution Regulation and Management Act of 2006. An act to regulate the establishment and management of non-government educational institutions in the state of Assam. Whereas it is expedient to regulate the establishment and management of non-government educational institutions in the state of Assam and for matters connected thereto and incidental thereto. So basically from this act, we want to have a control. basically to regulate. How they may have recognition and permission from various boards.
Why control? You are not aiding them.
We are not aiding them, whether they can do whatever they want to do.
Whatever they want, you have got the control through the recognizing body.
Exactly.
You already have on the areas wherein the control should be exercised.
Yes.
That control is already there.
Yes. That control is
But
not there. That is why we are interfering.
You can very well supplement those provisions
That is what
through the board.
through the board is a separate entity, Lordship.
Knowledge.
The board is totally autonomous body.
Yes.
Whether it is SEBA or Assam Higher Secondary Education Council. These are separate.
It acts as a representative or agent of the
Yes,
state
Lordship.
government.
Now,
So far as the non-governmental, non-aided institutions are concerned.
yes.
Anyhow, please carry on.
So I'll place the act first and what our stand, and finally what is the settled position of law.
Yes. Before we proceed, the other states must have promulgated similar laws.
Similar law, and I place Rajasthan's case
Let's see that.
from the judgments.
Yes.
Rajasthan, Uttar Pradesh, everywhere, Lordship, this is the position. And this is just to check the mushroom growth of public private institutions, where the main objective is commercial business entity, and they are treating their teachers in a very rude manner, in a very arbitrary manner. To
Yes.
check these two areas. One is that to charge exorbitant fees. That is
For that-
one area.
For that, the act is already there.
That act
For-
has come in 2018.
So
This act is of 2000.
yesterday, that was the thought process which was going on. It was probably the
That
state government.
act was an
in view of-
offshoot of this.
In view of the subsequent developments, RTE Act and the Act to control the fees, whether you need to reconsider this act.
Absolutely not, Lordship.
Really?
Why I am saying,
Okay.
the reason is very simple. That we have this problem in 2005 and 6, and we brought it into force in 2011, giving a retrospective effect
Yes.
of 2006. And whether we have enacted this act, whether state has the authority, whether state has the competence to enact this act or not, that is the first core area. Unless we do not have the competence, Lordship will definitely set aside. And what is the other ground? That it has to affect them in their fundamental rights. These are the two areas when this honorable court would like to set aside and say,
Consider the challenge, not set aside.
set
To consider the challenge.
challenge, and whether it is ultra virus or not, Lordship will have to look into that from that. Whether it is creating some hardship to them, that is not a ground to set aside any act.
Okay.
So now, whether we have the competence to enact this law or not, for that we have to go to the provisions of the Constitution, Lordships, the concurrent list under Schedule 7. Entry 25, concurrent list. That means both the state and the center has the power to legislate. Now, entry 25 says, education including technical education, medical education, and universities subject to the provisions of entries 63, 64, 65, and 66 of list 1, vocational and technical training of the labor. Now, here, if we look at the entry as education, it gives the competence to the state authorities to legislate. Subject that there's a rider that it should not violate the provisions of entry 63, 64, 65, and 66 of list 1.
Yes.
If we look at list 1, 63 says, institution known at the commencement of the constitution as the Banaras Hindu University, Aligarh Muslim University, and the Delhi University, etc., or any other institution declared by parliament by law to be an institution of national importance.
Right.
So 63 is out. 64, institution for scientific or technical education financed by the government of India, wholly or in part and declared by parliament by law to be institution of national importance. That is also not applicable.
Yes.
65, union agencies and institutions for professional, vocational, and technical training, including training of police officers or promotion of special studies or research or scientific or technical assistance in the investigation or detection of crime. So this is also not applicable. And 66, coordination and determination of standard in institution of higher education or research and scientific and technical institution. So none of these clauses are creating any problem in legislating by the state under entry 25 of list 3. So we have the competence. I'll support all this by the various judgments also, Lord. So we have the source of power to legislate. So we have legislated this. What is the basic objective? For that, Lordship, we will have to take your Lordship to the affidavit at page affidavit filed by the state of Assam through the respondent number 1. Here, the objective and intention of the legislative is very clearly elaborated in paragraph 4 onwards. May I please?
You're reading from which file?
I am taking this writ petition, WPC 2806 of 2012.
You not file any affidavit in 1891. There is no, the first writ petition of 2008. There is no affidavit by the state.
The association's case we do not have, Lord. But we'll rely upon this only.
Affidavit time.
Because that challenge is in both the cases is the act
Same.
itself.
Act, yes. Yes.
So paragraph 4. The government of Assam has enacted the Assam Non-Government Educational Institution Regulation and Management Act 2006 with an object to regulate the establishment and management of non-government educational institutions run by individuals, associations, or
You are reading the affidavit of R1 or R2?
R1.
R1, Nawab Mohammed.
Page number? Do you have a pagination?
Lordship, at that point of time, we did not have the pagination system of the affidavits,
No, it was there.
but it is.
It is there. Just- Yes, R1 we have it.
R1.
Yes.
So paragraph 4. The government of Assam has enacted the Assam Non-Government Educational Institution Regulation and Management Act 2006 with an object to regulate the establishment and management of non-government educational institutions run by individual, association or individual society or trust at primary, secondary and HS level, that is higher secondary in the state of Assam. So higher education is not included here. The aim of the act is to exercise control by the government over so-called many non-government educational institutions which have grown like mushroom in every nook and corner of the state without caring for real interest of the education. There is an increasing trend of commercialization of education, and many educational institutions have been established with the sole motive of earning profit with scant regard for the standard norm of land, building, classroom, furniture, library and laboratory facilities, fire safety measures, playgrounds, etc. The teaching and non-teaching staffs are paid meager salary and their services are terminated or dismissed on flimsy grounds without giving reasonable opportunity to defend themselves. As such, it is expedient to provide for law to regulate the establishment and management of all the non-government educational institutions functioning in the state and those to be established in future. Section 3 of the Act empowers the state government to regulate all the non-government educational institutions in the state of Assam in accordance with the provisions of this Act and the rules made thereunder. Regarding DPS, Lordship.
All right, we read that.
And
You say that in one writ petition they undertook, they would get registered and then they.
yes,
Like
that judgment also I will place, but
But they have a right to challenge. There is no.
they have a right to challenge, and
That
I am
judgment-
not on that.
That case was not pertaining to challenge to the.
But
validity of-
one thing was declared in that learned single judge's judgment, that they come under the provisions of the definition of 2G. Sorry. 2G. That remains unchallenged.
Their right to challenge the validity of that
No, validity,
cannot be taken away
I am
by
not
any
on that.
observation.
I
of
am
the
not on that.
Single bench
But
judgment.
one thing is very clear that they
Yes.
fall under the category of the definition. That is the
All right.
finding of this honorable court, and that remains unchallenged.
Yes.
So now, so paragraph 6, I am not think. Paragraph 8. The deponent begs to state that there is no central act or other statutory body to regulate CBSE schools. So 254 will not come.
Who are you to comment that CBSE bylaws? There is no effective mechanism.
I have a judgment of the Allahabad High Court to that effect.
We'll see.
Whatever I am submitting, it is backed by some authorities.
Okay, okay.
Nothing is coming from my mouth. In CBSE bylaws, there is no effective mechanism to provide for regulation of collection of fees. The state have concurrent power to legislate regarding matters of education, and the CBSE insists for no objection certificate from the state government for establishment of new schools affiliated under the CBSE in the particular state, so that there may not be any conflict between the rules and regulations framed by the state government regarding school education and the rules and regulations of CBSE. We took care of this, and CBSE also is aware of this. The agreement also I'll place. It is the bounden duty of the state to ensure that the private schools in the state do not indulge in profiteering business in the name of imparting education. And there has to be a mechanism to check the private schools from charging exorbitant fees. With regard to CBSE schools, the state government has the bounden duty to see that the fees collected by the CBSE schools are commensurate with the facilities provided, and to see that CBSE schools do not indulge in profiteering business or charging capitation fees, as there is no central act or statutory body to regulate the fees of the school. The deponent states that it has been observed that there is an increasing trend for commercialization of education. Many education institutions have been established with the sole motive of earning profit, and one of the grounds for bringing the 2000 Act in force is to regulate such education institutions who indulge in profiteering business in the name of imparting education. 9. The deponent begs to state that for the purpose to regulate the establishment and management of non-government educational institutions and to bring Assam Non-Government Education Institution Regulation Bills 2006, a cabinet memorandum was prepared by the government of Assam in the Education Secondary Department, by so and so. And in the cabinet memorandum, it was clearly stated. I am placing this to indicate before this honorable court what was in the thought process of the government at that relevant point of time. There has been a rapid rise in the number of non-government education institutions at primary, secondary, and higher education levels in urban and semi-urban areas of the state, including Guwahati city in recent years. The growth in the number of such private institutions being demand-driven, there has been a tendency to give less attention to basic infrastructure and affordability of major section of the people. The department is also alive to the concern of a section of the parents, guardians, and in general public on the issue of fee vis-a-vis the facilities provided by these private educational institutions and the Honorable Guwahati High Court direction in the matter. It is also observed that there has been an increasing trend for commercialization of education, where educational institutions need appear to have been overtaken by the commercial grid. Many educational institutions have been established with the sole motive of earning motive, with little regard to the standard norms of land, building, playground, safety measures, and other facilities. The teaching and non-teaching staffs are paid meager salary and their services are terminated arbitrarily. There has been a public...
Mr. Saikia, in a lighter vein, does the same logic apply to the legal profession also?
We have revised it.
We are asking you, does the same logic apply to the legal profession also?
It depends of that person who is there, because ultimately it is a case where
this is a matter of discussion.
It's a matter of discussion.
And a serious discussion at
because
that, particularly in Delhi.
In Delhi, one case, there's a very high price, and even the government of Assam is seeking to go to Delhi because of the high structure of fees. That we have to admit, Lordship.
Yes.
And that there's a regular articles in the newspapers and journals also on this.
Yes.
Whether there can be a cap or not, that is a debatable issue.
That's right. Okay.
But income tax is happy, Lordship. Income tax department is happy because the highest income tax pay are from those bracket of the lawyers.
That's true.
So the teaching and non-teaching staff are paid meager salary and and their services are terminated arbitrarily. There has been a public demand and there should be a regulatory authority on the management and conduct of these institutions. Since the existing acts and rules do not have provisions to regulate these institutions, appropriate legislature is felt needed. So the existing acts and rules we have taken care of. I'll place it, Lordship. The Act of 1961 basically governs all those schools who are in the government terrain. Very few private schools are under SEBA now, very few. And all CBSE schools, they do not come under the Education Department of Assam. Now, recently, last year, the state of Assam has inaugurated 10 schools having CBSE courses. This is a very recent trend, just to upgrade our students for the need, because Lordship knows in Tamil Nadu, there is a huge hue and cry in Tamil Nadu regarding the students that they are not doing well in NEET because their education system is different from CBSE. And according to the Tamil Nadu Assembly also, the CBSE students get a better position. They are in an advantageous position while appearing in the NEET examination. So that is now before the Honorable President Lordship for whether that act will be passed or not. The presidential assent, that act has been placed before the ministry, concerned ministry under the president's domain. So here we have taken into account all the acts also. I'll place each one I'll place. Similarly, for the purpose of bringing the Assam non-government education institutions rules 2007, the government of Assam Educational Department prepared another cabinet memorandum. The said cabinet memorandum says, with a view to regulate the private educational institutions, not the government ones. The governments are directly covered by those Act of 61 and all subsequent amended acts. The private educational institutions at primary, secondary, and higher education level in urban and semi-urban areas of the state, and the concern expressed by parents, guardians, and general public on the issue of fees vis-a-vis to check increasing trend of commercialization of education institutions. The Act 2006 has already been passed in the Assembly. Under the Act, powers to make rules, that is a rule-making powers for the elaboration. Yes. Now, this act, what is this act all about? We have to go clause-wise, Lordship, the section-wise. The main relevant sections I'd like to place. Number 1, section 1 says, this act may be called the Assam So-and-so Act 2006. It extends to the whole of Assam. It shall come into form the date when it is notification. This was notified subsequently in 2011 with a retrospective effect. 2G, non-government educational institutions means schools or junior colleges established and run by an individual or association of individual or any non-government organization or society or trust, except schools established by the maintained by minorities under clause 1 of Article 30 of the Constitution of India, imparting education at primary, middle, secondary, and higher education level without receiving any granting aid from the state government, and excluding the educational institutions run or aided by the central government or the state government. The word institution, wherever occurs in the act, shall be construed accordingly. So the state government and the central government schools are not included under this act. Very clearly, we have segregated. Number 3, section 3(1). The state government may regulate. We are basically on the regulation part. They have to register and will regulate. The affiliation, permission, all these things are to be granted by their respective boards. The respective board can be ICSC, can be CBSC, can be Assam Higher Secondary Education, Assam Secondary Education Board, whatever board they want to choose. We are not on that. The state government may regulate all the non-government education institutions in the state of Assam in accordance with the provisions of this act and the rules made thereunder. On and from the commencement of the act, the establishment of non-government education institution or opening of higher classes in or closing down of the existing classes in any existing non-government education institutions in the state shall be subject to the provisions of this act, the rules made thereunder, and any non-government education institution or higher classes established or open otherwise in accordance with the provisions of the act shall not be recognized under section 5 by the director and shall be closed down under section 24.
This is one issue,
Lordship.
it was troubling us. Director has been given the power of a state, almost,
Yes, Lordship.
and without there being any remedy provided against his actions. That is what the issue is. Do you have any-
Appeal provision, Lordship?
Yes.
That Lordship directs will do if it is not there.
It is read, you
Yes.
read, find
Yes.
out. Director takes it to his mind.
He
One
cannot,
fine
because he
evening,
will have
I'll
to.
close the school.
No, Lordship.
What is the remedy?
Now, what are the problems? The problem is exorbitant. That writ petition came because there are two structures.
Forget about that. Today we have a PIL listed in the court which has been adjourned. seeking a direction for registration of all the
Exactly,
schools.
that is what we
We
want.
understand, but the issue is
Unfettered power should
who
not be
is-
there with the director. If he is having arbitrary power.
the act is there. Read the
Act
act,
is-
read the provisions of the act. What
Yes.
kind of powers are given?
Yes.
One fine evening,
Yes.
the director thinks that all right, close the school.
No, he cannot do. He cannot.
That is what the provisions are.
No, Lordship. May I place it, Lord?
Read, please.
If we go through the complete act and the rules,
Yes.
everything will be very clear. And if
Read.
there is any lacuna, if any gap area, Lordship, gray area,
Read,
we can always supplement that.
read 3.2.
On and from the commencement, these two,
Yes,
no, I have just read 3.2.
3.2, read once again.
On and from the commencement of this act, the establishment of non-government educational institutions or opening of higher classes or closing down of an existing class in any existing non-government educational institution in the state shall be subject to the provision of this act. So there has to be provision in this act. The rules made thereunder are and any non-government educational institutions or other higher classes established or open otherwise, then in accordance with the provisions of this act, shall not be recognized under section 5 by the director and shall be
By
closed
the
down
di-
under section 24.
Yes. So the director has a power
Yes,
to
he has
close
the
the
power.
school one fine evening. One
Close
fine
the
morning.
school, close the school not at his whims and fancy. He must have a ground.
That is the question. If he doesn't have a ground and still he does it, where does the aggrieved person go?
Suppose, Lordship,
Yes.
suppose this act is not there. And instead of charging 100 rupees as fees, they are charging 2,000 rupees as fees. Where will that parent go? They will have to come to this honorable court.
Now that act is there. The act is already there to
Now,
regulate the
that
fees.
is one area. Now during the COVID, all these private schools were not paying their salaries to their teachers. Everybody came before this honorable court.
Yes.
And we take recourse of this act to help the honorable court to pass appropriate order that they should be paid 100% of their salary.
Yes, that's right.
This is 2 years ago.
That's right.
So this act is helping because when these schools are treating their teachers like slaves or like bonded laborers. Now, if Lordship looks at the fee structure, a government school teacher gets about 40,000 rupees and they don't get even 15,000 rupees.
So open schools everywhere.
That is why that mushroom growth of schools.
You open government.
We are not opening.
We are saying that you do that. It's your obligation.
No, we are
Education
opening.
is a state subject.
No, this is a state subject. We
Yes.
have ample number of schools. We have regularized, we have provincialized ample number of schools.
All right, carry on.
But
Yes,
these kind of activities, now what is
I
happening?
understand. There's no doubt about that. That regulation has to be there. There's no doubt.
Yes,
But
Lord.
there are
So
certain
whether
provisions.
there is
There are certain provisions
unfettered
which are.
power with the director,
That's
that is
what
there,
the,
that they are not showing, no?
no, they have done that.
Where-
That they have. You're not here.
No, no,
Yesterday, those were
where is the
provisions.
cause of action? They have to have an individual cause of action. Now,
No, they can.
what is
very
the
well
cause of
come and
action?
say
So
that
far
is
as
there is
DPS
an
numerical is
unbridled
concerned.
power. Unbridled power given in the
Yes,
act,
now in case
against
of.
which there is no remedy.
No, in case of, no, there's a remedy. I'll come, Lord.
Read
But
the
in
remedy.
case of, now, taking the example of the first writ petition, where my learned friend Barbara appears. That school was having two structures of fees. One for the students belonging to the NRL campus and one outside the campus. Two structures. They came to this honorable court and this honorable court found that to be arbitrary. You cannot have that kind of fee structure.
That's right. You can't distinguish.
So,
the students.
if this act was not there, where would have they gone?
That was done
The
by the court in 2 to
226.
6.
226 is always there.
That was
But
done
when we
by
have a
the court in 2
legislation,
to 6.
no, we have a legislation because we have the power under IM 25 of the
We have expressed us very clearly. The powers seem to be unbridled and arbitrary. Where is the regulation of the power itself?
Yes.
Who regulates the regulator? That is the question.
Now, I'm going, Lordship.
So us.
I'll show.
Yes.
Because they have to individually show that he has the power. Now,
Yeah.
no, Lordship, one thing is very clear.
Yes.
What is the language here? May I read it once?
Yes.
On and from the commencement of this act, the establishment of non-government educational institutions or opening of higher classes or the closing down of the existing class,
Yes.
any existing non-government school institution shall be subject to the provision of this act.
Yes.
So the director will have to act as per the provision of the act. He
Question is,
cannot,
There is no
he
definition.
cannot import something which is not there in the act.
Yes, like, yeah. There is no definition of The director has been given power of the state without there being any specific provision.
Yes,
In the-
Lordship, now that appellate provision is there in the amendment act of the same.
Where is the amendment?
Yes, that they have to bring it.
So that's what we are saying.
Yes.
That in the act as it was present.
28A. 28A.
Let's see.
This was inserted on 28 June 2018.
That's so.
Appeal provision.
At the first blush, what we are telling you, the act had many issues which required address.
No, they have to point out. They are generally saying the act is bad. On the ground that we do not have the
These
precedent.
petitions were filed in 2008 and 12 when this provision was not
No,
there. You yourself read-
their basic ground is, Lordship, that we do not have the legislative competence.
that is
because
regarding CBSE, only CBSE.
CBSE also they cannot take that ground, number one. And number two, that we must have taken the presidential assent under Article 254.
254(2).
That is not required because there should be a conflict. When it is a part of the concurrent list, Lordship,
Yes.
there should be a conflict with the central legislation, and there is no central legislation. I'll place a direct judgment on that.
We will see that. Yes, we'll see the judgment.
So now appellate provision.
Where is the provision? Has it been
It is-
placed on
it is in
record,
the book.
please?
It is in the book.
It's in the book. Okay, page.
I am also reading their petition, Lordship. I am from the paper book.
Page.
Now, whether after this amendment, Lordship, they must have bringing it to the notice of this honorable court.
No, they did point out.
Appellate provision.
They did point out, yes.
Then appellate provision is there. Any non-government education institution or any individual non-government organization, society or trust, as the case may be established, any non-government education institution aggrieved by the order of the director passed under the provision of this act may prefer an appeal before the state government against the order of director within 30 days from the receipt of the such order. Decision of the state government in such appeal shall be final and binding on all concerned. They can still come to under 226.
Yes, of course, that remains. Yes.
So we cannot, the director is not given unfettered power, Lordship. There are certain checks and balances.
Let's see that.
Yes, now going further. 4.1. Prior permission for establishing of non-government education institution and registration.
Yes.
Any individual association or of individual
Forget
non-government.
about this next part, their grievance was regarding the
Lordship, let me go
the
serially, Lordship.
management committee.
School management committee.
Yes.
They have to insert two persons from the private sector also.
Let's see that provision.
That is a
Whether
part
that is not in conflict with the TMA pipe foundation case. Come to section 14. 12. Read section 12.
they have to fulfill all the criteria of section 10. And we have given some exemptions under section 14 also. I'll place. But now, as Lordship is saying, 12. So I'm
Yes.
going to 12.
Hmm.
9, 10, 11, 12. Yes. Constitution of Management Committee. Every non-government educational institution shall constitute a management committee consisting of the following. The chairman or president or principal of the managing agent of the society or trust or the
Right.
association of individuals or the person or individual establishing a non-government educational institution shall be the chairman. So the chairman belongs to them. Headmaster, principal of the institution. Number 2 is also there.
Yes.
2 representative to be elected or selected by the guardians.
And that is fine. That is absolutely
yes.
okay. They
2
have to
teachers, lecturers of the institution elected or selected from amongst themselves. Any person who shall be an educationist of the locality.
Who nominates this person? Is there any provision for
Under the
nomination?
rules, there must be some. I'll check it.
Okay, very well. And
Any
2
person who
members-
shall be educationist of the locality. Number F.
Yes.
2 persons to be nominated or elected by the society or trust or association of individual societies, individual, etc., and running the institution out of which one shall be chosen by the member secretary.
Chosen.
So it is
So
their
this is not
nomination.
nomination to be done by them.
So everybody belongs to them. Where is the government representative here? The term of the managing committee shall be 2 years.
Okay.
So the earlier case, Lordship, they did not have the 2 representatives from the guardians. That was one of the core area of challenge.
Okay. Yes.
So we are not trying to usurp their power. They do whatever, but the certain norms, certain principles of the society has to be followed.
Yes. All right.
I am coming back to section 4 now.
Yes.
Then again, Lordship, the 4.1, that is permission. And any individual association, etc., may submit an application before the director in such form containing such particulars and information as may be prescribed. So the director cannot ask anything which is not prescribed for obtaining prior permission for establishment and running of such institutions. The undertaking shall be a part and parcel of the application form and shall be prescribed. On receipt of the application, the director, after considering the particulars and information contained in the application under section 1, and after making such inquiry as may deem necessary, may either grant or refuse to grant prior permission to the applicant for opening of non-government. So he will pass an order, provided the director may refuse to grant permission if he is of the opinion that the particulars and information furnished in the application do not fulfill the requirement as laid down in the act and the rules made thereunder for reasons to be recorded in writing. On refusal to grant permission under subsection 2, the director shall communicate the same to the applicant stating the reasons therefore. 4. In the event of refusal to grant permission under subsection 2, the aggrieved individual, association of society, etc., may prefer an appeal before the state government whose decision shall be final. So this is their
non-recognition.
This was not
non-grant of permission.
Yes, in case. So that was there, even the appeal provision was not there.
That is only on the aspect of
Appeal for
non-grant of permission.
Yes.
Now the general appeal provision.
General appeal provision 28A has come.
All right.
The permission granted under subsection 2 shall remain valid for a period of 2 years, within which the applicant shall establish the institution and register the same before the director. If for any reason which the director considers to be genuine after an application being made in this behalf by the applicant who has failed to establish the institution within the stipulated period of 2 years, the director may grant extension of the time for further period which shall not exceed 1 year at all, within which the applicant shall establish and register the institution. Now, administrative recognition. After establishment and registration of the non-government educational institution under subsection 5 of section 4, the authority shall make an application on payment of such fees and in the form and manner as may be prescribed before the director for obtaining administrative recognition in respect of the institution. Then the process is there, Lordship, including transfer. Now coming to 6, registration and administrative recognition of the existing non-government. So they were given a time period.
Yes.
4. The existing institutions which have been established and run with or without the permission or recognition of the state government or director, without having the minimum required as laid down in section 10 of the rules made thereunder, shall have to fulfill the requirement within a period of 2 years from the date of commencement of this act, and after which the institution shall be finally registered. So
Now,
that 2
Mr.
years
Chair,
leeway is also given. to
just
them.
hold on. Supposing an institution is functioning for last 50 years.
Yes,
It has got 1 bighas of land only.
yes,
Now your requirement is 2 bighas.
yes.
Where will they go?
Where will they go, Lordship? That individual case will have to be handled individually. But for that, the act will not become ultra virus.
All right. Okay. Yes.
The existing institution which have been established or run without the permission and recognition of the state government and fulfilling the requirement as laid down in section and rules have been thereunder shall apply for obtaining administrative recognition from the director within a period of 6 months from the date of commencement of this act. After giving administrative recognition, this institution shall be finally registered. And those who do not fulfill it has to be closed down. Lordship, 6.
6, yes.
The provisional registration and recognition, etc., of the institution which have failed to fulfill the requirement as laid down in the act and the rules within the time frame stipulated in this section shall be liable to be cancelled and the institution shall be liable to be closed down under the provisions of this act. So if whatever situation Lordship has just said, that 50 years, 1 bigha, they will come under this, that it will have to be closed down. And in that case, Lordship, this particular section, they could have challenged whether this is too harsh or not.
Okay. Very well.
But certain things, Lordship, we cannot compromise, like the fire safety measures.
Oh, no, of course, there is no question. There are other statutes for that purpose.
Lot of
Municipal laws are there.
yes,
for that.
the building bylaws.
Building bylaws are there for that purpose.
Constitution of
Those
Administrative Recognition
basic
Committee.
infrastructure, they will Everyone has to provide.
So now,
After all, it's
Lordship,
a matter of
there's
safety
a
of
committee also for administrative recognition. Who
Hmm.
is the director, is the chairman, joint director, one state government representative, not below the level of deputy secretary, secondary education. Then one representative from the board of SEBA, then Assam Higher Secondary.
Psychiatry, otherwise
That
also,
means, Lordship, the director is not the sole person to take a call.
psychiatrist, wait. They have not particularly argued on any particular section.
Exactly, that is what.
So let us see the law which you are citing. Let us see the law which you are citing. You say that similar provisions, similar acts have been upheld by other high courts.
Yes.
Let us see that judgment. How those judgments
Yes.
deal with.
In Rajasthan, when this RT Act came in 2009, lot of requirements were there under the RT Act, section 23, the regulations and their Societies of Unaided Private School of Rajasthan versus Union of India, 2012, 6 SCC, page 1.
Have you given the list?
Yes, we have given
You
it.
know.
2012, 6 SCC,
Hmm.
page 1. Here they will definitely say that that is in respect of the central legislation.
Hmm.
But in our case, there is no conflict on the ground of competency. The state has an act which is covering the field.
Hmm.
There is no other act which is covering the field.
Hmm.
For that, Lordship, I'd like to place one judgment before going there.
Sure.
The 2017 judgment. There is no. No.
Yes.
I'll move it across in this. Move on, huh? এখন যে আছে অকল physical education আৰু technical education.
Mr. Saikya,
Lots.
argument in Malegaon was that it is a school run by the central government because aided, totally aided by the.
Yes,
or funded by this.
Straight way I can come. Straight way I can come to that.
Yes.
Lordship will take their agreement.
Mhm. Page.
Agreement is at page 26. It starts
Mhm.
and page, Lordship, 29.
Mhm.
Here, the agreement was executed between NRL and DPS.
Mhm.
Page 26. This agreement is entered between Malegaon Refinery, a company called Incorporated so and so,
DPS.
and Delhi Public School Society,
Yes.
registered under the Societies Act of 1860.
Yes.
Lordship will kindly come to clause 8H.
8H. Yes.
The school building, furniture, fixture, fittings, library materials, sports materials, etc., provided by NRL will be given on rent to Delhi Public School Limited, Malegaon. In consideration thereof, NRL will charge a rent of ₹1 per annum and all assets and will be transferred to NRL on termination of the agreement. So basically on rent, they have taken the premises. Just like I am having a McDowell shop. I have a McDowell outlet, Lordship, in a club premises. They have taken on rent for 50,000 per month.
Okay.
That and McDowell property will not belong to Lordship. It is a franchisee.
Franchise.
It is a franchisee. Here also DPS has taken franchisee
Franchisee.
of running that school. In Guwahati, there are 3-4 DPS.
Yes, yes. DPS is a private
It's a
organization.
private organization.
Yeah, that's right. So where's the question of funding being given by the center?
That is what they have to show.
Yes.
27 of.
Right.
They want a school to be operated in their campus so that the students of the employees of NRL can take education. They can have all the employees in and.
Oh, there's no question. Yes.
Clause 5E also, Lord.
Of this license agreement?
Yes, same agreement.
Yes.
5E.
Hmm.
Yes. So 5E says
Now that is the
to fix the
discrimination.
fee structure of the school so far as to cover all expenditures of recurring nature to run, maintain and manage the school with a discretion of charging higher fees in respect of non-NRL employees. So they are charging fees and etc.
No, yeah, there's no dispute about
There
that.
is no dispute. So it is not as NRL's own school. Today, at the end, Lordship, if
They only
come out,
provided the
they have to
premises.
hand over everything.
They only provided the premises
Exactly.
at a
Exactly.
nominal rent.
If Lordship allows our canteen to be run by one franchisee,
Hmm.
like Starbucks, Lordship, that will not become Guwahati High Court's property. The property belongs, the canteen belongs to Guwahati High Court, but it is if you look at the property of that canteen, Lordship, it belongs to Starbucks. Now state government is having Starbucks in that heritage center. It is not a state government's property.
That's right. Yes, okay.
So it is not because that exemption is already there under 2H. Those central government funded, state government funded school will not
The
come.
exemption is already there.
Exception is on will
For
not.
them to claim the benefit of the exemption, they will have to show that they are funded by the central.
Exactly, Lordship.
Right.
They are trying to mislead this one. I am using this hard word. But they are trying to
We are
mislead.
hearing you now.
Yes.
We are hearing you. We are
I'm
not,
clarifying.
we are not
I'm
deciding the
clarifying
case.
because I have heard that they are saying that this is central government.
That was the argument. That's the pleading.
There's a
Where-
pleading also. Yes.
That's the
it is a
pleading,
pleading
so-
also. Yes.
You must have countered that.
Yes. I'm going, Lordship.
We'll
Whether Lordship would like to continue it is
we'll
one,
continue to,
or maybe tomorrow, Lordship, because I'll take a lot of time, Lordship.
no, we don't have any problem.
Yes,
We are-
then I can
if
continue.
you have any
I
difficulty,
I have no
so
difficulty.
then we'll continue.
Yes, if
We'll continue.
yes, Lord.
We'd like to finish it off.
Yes, Lord.
Rare are the occasions when we are engaged after one.
Lordship, Lordship, I seek a little accommodation, my lord.
Yes.
Item number 33, my lord, I had advised my colleague to make a mention so that a date may be fixed for disposal of the PIL. But
Okay.
inadvertently, it has been
Very well.
disposed of.
We will adjourn kar dena.
Deeply obliged.
Deeply obliged.
Yes.
May I continue with the act?
Sure, sure, definitely.
So I am coming, I was up to section 8, Lordship. Now, section 9, that is important. Section 9 says, grant of prior permission and administrative recognition to establish and run an institution under section 4 and 5 respectively shall not cast any obligation on the state government or the director as the case may be in respect of granting academic permission and recognition by the Board of Secondary Education Assam SEBA or the Assam Higher Secondary Education Council or any other board, council or body under the state or central government or under any statute which shall be governed by the respective rules and regulations of the concerned board, council, body as the case may be. So the state will not interfere with the other
Recognition part is concerned.
Yes.
That is the domain of the body is
Yeah,
concerned.
exactly, Lordship. Next, Lordship, number 10. No government education institution shall be established or run or prior permission and no prior permission or admissive recognition to such institutions shall be granted unless the institution fulfills the following requirement. This
So
is
infrastructure, basically.
basically infrastructure. And there is also Roman 4. The institution shall not run for profit to any individual, association or individual non-government organization, societies.
Now, what is the rationale behind this clause 4? Tell us. Why
Basically,
not? Why not? Supposing a private individual is starting a school
that
of excellence.
nominal profit, that is a business associate, that is it. But when,
But how can you control that? sir?
yes, therefore, they have to give us a scheme under section 14. That scheme,
Question, you are reading
I'm reading
10 subclause
4. That sole motive of profits is not permissible under the act.
sole motive is different. Just now you are ruling out profit entirely. So are they doing it for charity?
No,
Then-
the thing is that we have to read it, the act as an entirety, as a
Yes.
whole.
Mhm.
If the whole act divorces this, then that is not permissible. We are allowing, Lordship, 15% of management fees and all that we are permitting. That is also backing of the
Whether-
Supreme Court.
whether you
And
can-
on top of that, Lordship,
Mhm.
they have to give some free seats to some courts. All these things are there.
That's all right. But what they earn out of it after having the cap of fees, how they manage their affairs, how can you
No, we are not doing it.
put a
But
restriction
they
on
have
that?
to give us a scheme.
Clause 4 read once again.
Yes,
Explanation and clause 4.
4.
Mm.
4's explanation is not there. Explanation on top of this is
Now,
there.
clause 4.
Clause 4,
Institution shall not.
run for
Mm.
profit to any individual.
So you totally rule out to profit, rule out the concept of profit.
This is not their case, Lordship. If they are
It was
asking,
their
then we
case.
disclose everything.
It
Now
was their
let-
case.
Now, the
It was
thing is-
specifically the argument.
Yes, then let us read the whole act, then after that, whether this is permissible or not.
Okay.
Coming to Roman 12 sanitary arrangement, 13 is drinking water, 14 is discipline, 15 is no teacher or student of the institution shall be compelled to attend a class in which religious instruction is given or take part in any religious activity. So
No,
there
that is
cannot be compulsion.
That is fine.
Yes.
Hmm.
16, the institution shall be open to inspection by any of the following officers, any officer authorized by the director, then medical education officer, etc. Now coming to 12, 12 is the constitution of the committee, management committee, where there is no representative from the government, which I have already
That's
placed.
all right. Yes.
Now coming to 13, powers and functions of the managing committee. The managing committee shall have control over the appointment of the employees, disciplinary action against the employees, and overall administrative control of the affairs of the institution. The managing committee shall not conduct the affairs of the institution in such a way which may adversely affect the interest of the institution.
No, Mr. Saikia, there's one issue. They want to make a selection of the teachers. Why should the parents have a say in that?
Parents have a say on
Why? Why?
Why?
Do you allow?
Because-
do you allow?
because-
Just hold on, please. Do you allow the parents of the students studying in the convent schools to take an interest in the selection process?
not in the whole, but in the school management committee of the state government schools also. In
Selections.
selection, no, there's a totally.
That's what this clause, because management committee contains has an element of two representatives
Yes.
from guardians.
Now,
No.
yes, here, because in the government, we have to follow the norms of eligibility. Here, if the private school is suppose inducting a teacher who does not, he's not properly qualified.
You can, while granting the recognition, the board, secondary board can say that you will have graduation for a teacher or post-graduation. for a
Yes,
particular-
now,
You can very well say, but what person is to be selected? Why that discretion? Why that interference?
are they complaining about the induction of two public, private?
They are
persons from the
complaining about the entire act. So we have to read every provision.
Yes.
So unreasonableness, arbitrariness, and
Arbitrary, they have
unconstitutionality.
to pinpoint.
19(1)G.
They have to give us, not vaguely they can say. Just for the sake of in a very general and casual manner, if they say the whole act is bad, that is
That
one
is why,
aspect.
Mr. Saikia,
That
when
is
you are
one
reading,
aspect. The other aspect is.
when
we
you are
have to
reading
pinpoint.
every provision of the act, and when we are putting you to test, or rather we are testing its constitutionality on that anvil, this is a query which has cropped up.
No,
Now you have to satisfy.
my submission will be very clear, Lordship.
Yes.
They are challenging the whole act, act as a whole, on the ground of competency,
As well as unreasonableness, arbitrariness.
which provision they have to point out. What is their factual basis for that?
Yes.
Now, when Lordship is rightly saying that whether that two parents or the two guardians, they have a say, they are not majority there. How many members are there? We have to see, number one, and no guardian will allow any teacher to be appointed who is not qualified. The problem here is Lordship.
Qualification, Mr. Saikia, we are absolutely with you. Qualification,
Then
you can
if Lordship
prescribe.
wants that the two persons should be out, we'll be more than happy.
No, not that, not
We'll
that.
be more than
Mr.
happy.
Saikia, it's not a question of, we can choose. We are saying when the scheme of the act is being
The
analyzed.
scheme of the act, ultimately, who will frame the scheme? The scheme is to be framed by the management committee. Next 14.
Yes.
The school, the managing
That is
committee
salary
shall
structures.
frame a scheme.
13(1).
13(1). The managing committee shall have the control over the appointment of the employees, disciplinary action against the employees, and overall administrative control of the affairs of the institution. This managing committee, Lordship, what they are basically arguing is that government should not have any control.
Government control.
The government
otherwise
control,
also-
they do not want. Now, when the managing committee, where there is no representative of any government, Lordship, the whole thing is given to them. So where is the problem for them now?
All right.
If they are having problem with two persons from the guardians fraternity, Lordship, then that is a different issue.
All right, come to 14. Yes.
The managing committee shall frame a scheme of the management of the institution containing the salary structures and other conditions of service of the employees and the fee structure of all levels of the education, amongst other things, as may be prescribed, and which shall not be inconsistent with the provisions of this act and the rules made thereunder, and shall submit the same to the director for consideration, acceptance, and record. No levy of any kind of fee shall be made or imposed by the institution in excess of the fee as fixed by the in the scheme
So
of the.
now where is the salary structure provided?
Sorry, Lord.
Where is the salary structure provided?
Salary structure provided, it is their domain.
And the
Because it is
director
not
has,
that,
director has a right to
no,
outright reject it. That's the
when
power.
it is done, when it is done in a different manner, then he will have to give a reason. Suppose, let me submit before this honorable court. The fees which has been charged by Assam Valley School, which is one of the top public school in the country, Lordship, their charge is 10 times more than what is being charged by Don Bosco School in Guwahati. Both are unaided private institutions. In case of Assam Valley, Lordship, there is maybe a rationale to charge a higher fees because the facilities which are given by Assam Valley,
That's right.
or to DPS school.
You have Jindal School, Law School, which is charging out of the nose, and the national law colleges, they charge hardly anything.
So that application of mine have to be there of the director.
Question here is, in this part, section 14(1),
Yes.
acceptance of the director salary structure. Who is the director to decide?
Who is the director?
This is totally unacceptable.
No. That Lordship may say.
Salary structure, how can the director decide?
The director has a committee. It is not that he himself will do.
Read.
Yeah, that is why let me first place the whole act. Then the scheme will become very clear now.
Yes.
2, no levy of any kind of.
Read 14(1) complete.
The managing committee shall frame a scheme of management of the institution containing the salary structure and other conditions of fees, other conditions of service of the employees, and the fee structures in all levels of education, amongst other things, as may be prescribed and which shall not be inconsistent with the provisions of this act.
Now let us pause here.
Yes.
What are the provisions of that?
Yes, that is why I'm want to go to the whole act, because there are certain provisions little bit later.
Okay. And shall submit the same to director for consideration, acceptance.
And what happens thereafter, Lordship? No levy of any kind of fees shall be made or imposed by the institution in excess of the fees as fixed in the scheme of.
All right. The scheme of that the management decides.
Number 3 is where the answer is there. The director may approve or disapprove the proposed increase in fee if he is of the opinion that such an increase is necessary due to increase in the facilities provided in the institution, and may disapprove for reasons to be recorded in writing. So he will have to give reason, whatever.
Absolutely unacceptable. Now you have a statute for that, where there is a cap of fees.
That is not their ground. That is not their ground in their writ petition.
That has come out subsequently.
No,
Lordship, this condition.
Whether this
wait a minute, sir. Wait a minute.
Wait
a minute, sir. Just a minute. Mr. Saikia, just a minute. Taking the act as such, who is the director to decide? The parents.
Director is empowered here. The state government has empowered him.
That is why this is under challenge, sir.
No, if Lordship has something against the director, that is a different thing. But then let it be secretary then. But some person have
any officer for that matter, who is he to decide the fee structure of a school?
Yes,
he doesn't get a single penny from the government.
That can be one way of looking at the thing.
Yes.
But the other thing is that the director is not.
You were just now telling.
Director is not an individual.
It's like
director is not an individual.
Mr. Advocate General, just listen to us now. You just now gave us the example of Assam Valley.
Yes.
It charges, say, supposing per student per year,
suppose
1 lakh rupees. All right. Now your director one evening wakes up and says, no, I will not allow more than 10,000.
Yes.
Yes.
For that, he will have to follow 14(3).
Yes.
14(3).
So he gives reasons, in my opinion, it's not just.
And if his reasons are not acceptable, this honorable court can set it aside.
Why the parties are, the people.
Lordship, that is the rule of law.
No.
That is the rule of law.
No. Absolutely no.
No,
giving this kind of, this is draconian power.
Director is the first authority.
Draconian power given to the director in the scheme of the act.
This act, and director will have to take a call.
All right. You say that this power is justified. We'll take a call on that.
No, I'll justify, Lordship.
Yes,
I'll place the whole act. But the thing is that somebody will have to act at the first instance. He is not the last instance.
What spheres?
The last instance is the Supreme Court. The last instance.
What spheres, Mr. Saikia? The question is, what spheres you can govern? Security of students, service conditions of teachers. Yes, understood. Perfectly. Infrastructure, understood.
Yes. There are a lot of, I'll place, my argument is not over. I have to place complete facts.
We are putting
I am
your
just
queries.
placing the facts
If
and
you are-
I'll sum up my argument on each point.
Very well.
I'll not
All
leave
right.
anything.
Carry on.
Whatever query this honorable court poses, whatever ground they are taking, I will have answer to everything.
Okay, carry on.
If I place the complete facts and what are there in the records.
Yes, carry on. Okay.
Now, 3 says,
Hmm.
the director may approve or disapprove.
Hmm.
Suppose he disapproves, let us take it negatively.
Hmm.
Then what he has to do, the proposed increase of fees, if he is of the opinion that such increase is necessary due
Yes.
to increase in the facilities provided in the institution and may disapprove for reasons to be recorded. These reasons which he will give by the speaking order
All right.
is not the words of the Bible.
Okay.
It
Very
is
well.
subject to further testing.
Okay.
One is section 28A,
Mm,
the
yes.
appeal. If they are not happy, if it is rejected, they can appeal.
Okay.
The higher authority will look into it. If the higher authority also sails with the director,
Mm.
then they can come under 226.
Very well. Okay.
And ultimately, whatever the Supreme Court will finally decide, that will, if everybody wants to take it to the last forum available to the school authority. But they will have to take a call.
All right.
Suppose the state government accepts it. That is
Mm.
the end of the matter.
Yes. Okay.
The scheme 4, the scheme of management shall provide educational qualification for the teaching staff of the institution which shall conform to the qualification as fixed in respect of the government and provincialized primary, middle and secondary, higher secondary school education as the case may be. So the educational qualification has to commensurate and it has to be in tandem with the prevailing law in force in respect of all schools.
Yes.
Because the students must get properly qualified teachers.
Mm.
They cannot dilute the qualification of the teachers.
Right.
In case the managing committee or school authority or any persons involved in the management of the institution shall violate the provisions of the, in no case that they cannot violate. Now, coming to the disciplinary point.
Mm.
15, the school authority shall issue appointment letters in the event of any appointment made by to any person in regard to its affairs, and such appointment letter shall clearly state the terms of appointment, salary and other conditions of service in respect of such appointment as per scheme of management of the institution.
Mm.
No employee of an non-government educational institution shall be dismissed, removed or reduced in rank or terminated without giving an reasonable opportunity of being heard and without the matter being referred to the managing committee for its consideration and approval.
Yes.
So I don't think there can be any quarrel on this.
Mm.
Provided that the school authority may suspend an employee with immediate effect without the prior approval of the managing committee, if it is satisfied that such immediate suspension is necessary to by reasons of his gross misconduct under the code of conduct framed under section 16.
Mm.
The procedure to be followed in disciplinary matters shall be such as prescribed. Now pausing here for a moment and let us see how the scheme is to be framed under the rules.
Yes.
Page Lordship 57.
Mm.
Scheme of management under section 14 of the Act. This is under the rules, Lordship.
Mm.
Each and every non-government educational institution shall prepare and submit to the director a scheme of management with the following provisions.
Mm.
Power and function of the chairman, the secretary, the manager, and the headmaster or principal of the institution.
Mm.
The procedure to be followed for constitution of the managing committee, power and functions and tenure of the managing committee. Procedure for selection, appointment, promotion of teaching and non-teaching staff.
Mm.
Now, Lordship was putting a question that why these 2 persons from the guardians fraternity will be included.
Mm.
So everything will have to have a particular system.
Mm.
Nobody can deviate from that.
Yes.
The scheme has to be done by them, not by us. But only criteria or only precondition is that the educational qualification or eligibility criteria of the teachers who are to be appointed there, they must be following the terms, the criteria as laid down in the general law.
Yes.
Qualification of for teachers and non-teaching. D. Salary structure for teachers and non-teaching staff, service conditions of the employees, code of conduct for the students, manner of supervision, guidance, control of teaching and non-teaching staff, students' fee structure indicating rate of admission fees, tuition fees, game fee, library fee, festival fee, development fee. These will include lordship development fee. It is permissible for construction of their building, etc. These are all permissible areas.
Yes.
Other fees as per student class-wise. Procedure for admission of students and provisions for concession, exemption of fees to any student. Manner of collection of voluntary contribution. This is also permitted, lordship. From parents or guardians and others under section 19 of the Act. We have procedure for taking disciplinary action against students. Provisions for professional development of teachers. Provisions of contributory provident fund, employees provident fund, welfare schemes, teaching and non-teaching staff. So these are the general areas where the scheme has to be formulated.
Yes.
In lot of schools, there is no scope for provident fund, GPF, contributory.
Well, for that, there are specific provisions in law. This statute can't substitute those laws.
Yes, lordship.
There's no doubt about that.
There is lot of flouting also of that.
For that, there are provisions in the
Statute is also
statutory
there.
provisions.
So what is
So
the
that
harm?
this-
What is the harm if we want? There are a lot of
This is
overlapping
not a
areas.
question of harm. You are encroaching on the field of central law. That is the harm.
Yes, which central law now, lordship?
Provident Fund Act.
Provident Fund Act.
Yes.
We are, when
EPF Act.
EPF Act now, what we are saying, that you follow EPF Act.
So that is, do you need to say that? Do you need to say that so prepare 10 more acts?
Now, let us come to the agreement with CBSE for a moment, lordship. CBSE's agreement, what they want. Page 27.
Yes.
This is the agreement between Malegaon and DPS. The agreement that DPS authority says, K, page 27, to ensure compliance of all statutory requirements as may be applicable from time to time.
Yes, all right.
So if we are repeating it, we are not
then
saying
all
that.
right.
Now, if we had now, lordship,
So this means in common parlance, washing soap with soap before washing your hands.
that is one way of looking it. But the other way is that when we say that now onwards, the school scheme should not include that they should have any contribution under EPF, PF, etc. If we say the reverse, then that would have been in conflict with the Central Act.
You need to say that you shall act as per law.
So now we are saying that you do it.
Okay, very well.
That does not say a lot of things we have to say.
If the provisions are
Now,
shoddy,
in the
you have to
advertisement,
agree.
suppose
You have
an
to
ad-
agree.
In an advertisement we have issued, suppose for the state government, we issued an advertisement for
Yes.
teachers. We can say that you have to have TET, BA, BCom or BA graduation degree.
Yes.
Or we can also say
As
that
per rules.
as per rules.
Yes.
What will do? When we say that we also
This is not
have-
an advertisement, Mr. Saikia. You are making a law. Law which says that you will follow the law. Does it require
These
Constitution of
rules-
India
these
says so?
rules are that scheme must include all these things.
All right. Very well.
What the scheme
Okay,
will
carry
give, we
on.
are giving, we
Carry
are
on.
giving the scheme, the particular format.
All
In the format we want that, you kindly indicate whether you are deducting or you have any scope for this kind of contribution,
All right.
deductions.
Yes. Yes.
So section 14 NV says is a scheme. And a scheme we have indicated all these things. That this scheme must include these particular parameters which the school authority will have to submit before us.
Yes.
Now, going back again to the Act, Lordship. Now, section 15. The school authorities shall issue appointment order in the event of any appointment made to any person in regard to its affairs, and such appointment letter shall clearly state the terms of appointment, salary and other conditions of service in respect of such appointment as per scheme of management of the schools. So in the management scheme, Lordship, the state is not interfering, only we are approving whatever they are giving. But if they want is not complying with certain conditions, then it is separate. They are given an opportunity to rectify it.
All right.
No employee of a non-government education institution shall be dismissed, removed, or reduced in rank or terminated without giving him a reasonable opportunity of being heard and without the matter being referred to the managing committee for its consideration. So we are also including that principle of natural justice here. Provided that the school authority may suspend the employee, etc. Now, 16 code of conduct of the employees. Every employees that what the employees have to do. Curriculum and syllabus. 17. The course of study, curriculum, textbooks, syllabus, etc. for the non-government education institutions shall be such as may be specified and recommended by the affiliating or recognizing authority, board, council, as the case may be, under their respective state or central government. So the SEBA, ICSC, CBSC, whatever board they are affiliated to, they can have the syllabuses. Admission fees. 18. A child who has not attained the age of 5 shall not be admitted in class 1 or an equivalent class or class higher than class 1. So our educational policy contemplates that the minimum age at which the school have to admit a student is 5 years. For commercial reasons, they can do it at 3 years also, which is barred here. The preschools are different, Lordship. This act is not covering the preschools.
All right.
The Euro kids and other schools. They can induct the students at 3 years also. But here, the minimum age is 5 years.
Yes.
A student seeking admission in non-government education institution in any class higher than class 1 shall have to submit original transfer certificate, etc. from the school where the student studied last to the head of the institution, etc. 3. Admission of students in non-government education institutions shall be made without any distinction of religion, caste, creed, etc. These are constitutional backing we have. Every recognized non-government education institution shall reserve 5% seat for admission of meritorious pupil hailing from poor family as recommended by director in this behalf. Such pupils shall be selected as per norms. We have amended it. The director has been replaced by the deputy commissioner now. This has some backing of this honorable court judgments as well as the RTE Act. The students admitted against the reserve quota as provided in under subsection 4 shall pay fees as may be fixed by the director in consultation with the school authorities on receipt of an application from the pupil in this behalf. So when there is a waiver also, Lordship, the director will not take a call on his own. He will discuss with the school management authority, school authority.
Yes.
Prohibition of compulsory donation. No non-government education institution shall levy or collect any donation compulsorily from any student or her parents, guardians, provided that the managing committee with prior intimation to the director may invite voluntary contribution from the parents or guardians for the construction of any building or for the school or extension of building or hostel or any other facilities to be provided to the students. These also, Lordship, we have given the full leeway that the school management committee can collect compulsory donations also with the approval of the director. If they have some good purpose, the purpose should be indicated.
Yes.
Inspection or supervision. The director or any officer authorized in this behalf may enter at any time with or without notice any place or building or premises which he or she has reasons to believe is being used as a non-government educational institution. So to inspect that power we are taking, Lordship, because
Yes, carry on.
Because the building should be, there are a lot of incidents of fire and breaking during the earthquake here.
Is he taking the role of a sanitary inspector?
What he say, the director or any officer authorized in his behalf. It is not the director. He can authorize any person.
Okay.
The Lordship may laugh at it, but the thing is that the director, one point the government is entrusting. He can either do it himself or authorize it. Suppose it is for inspection of the toilet facilities. He will definitely induct a person from the health and family welfare department or the Guwahati Municipal Corporation, if it is in Guwahati. The director or any other authorized person in this behalf may enter at any point with or without notice any place or building or premise which he see has reasons to believe is being used as non-government educational institution. Make such examination of place, building or premise or inspect any place, building or premise, equipment, articles or documents, including.
Now the director becomes here, DRI, PMLA, all included by this provision. Read carefully.
Yes. Including financial transaction and seize any other such equipment articles.
So director at Win says, I'll seize all your. computers."
Yes, that has been approved by the Supreme Court. I'll place judgment.
Of course, we'll see.
Seize any other equipment articles, documents deemed necessary for the purpose of examination, investigation, or collection of evidence, or retain them as long as necessary.
Investigation of what, sir? Investigation of what?
Or collection, investigation of overcharging.
Do you indicate here? Do you indicate here?
Yes,
That what
the
is- what is
financial
the purpose of
transaction.
this?
We have to read it along with the financial transaction, and it has to be supplemented by the rules also. There's a procedure.
All right. We'll see your Supreme Court website. Yes.
After making the inspection, the director or his authorized officer carrying out the inspection shall furnish a copy of the inspection report to the manager or managing committee of the non-government
Even a
education
police
institution.
officer cannot enter a private building without a search warrant. Director is given power to enter a private building at his whims at any point of time and
So
seize
many
anything
sales tax officers are empowered under seizure and search and seizure
after
procedure.
proper authorization, sir. Not
They
without that.
themselves are quasi judicial
After-
authorities.
After proper authorization.
They
When there is,
themselves,
when there is
the
an
act
allegation,
empowers. The VAT Act and the State Sales Tax Act empowers them.
under certain conditions.
Yes,
The
here
law
also,
says, this provision doesn't say under what condition. At his whims he will enter, at his whims he will seize. What are the preconditions? Let us know.
yes, I am coming, Lord.
Yes.
After making the inspection, the director or his authorized officer
Yes.
carrying out the inspection shall furnish a copy of the inspection report to the manager or managing committee of the non-government education institution to act upon and for compliance thereof.
Yes.
Utilization of fund. Money received or held by or on behalf of concerned non-government educational institutions shall be utilized for the purpose for which they are intended and shall be accounted for by the school authority in such manner as may be prescribed. Suppose they are charging money, suppose 2 lakhs rupees from each of the students for construction of the school building, and they are not doing it. How the director or the government will find it out? Director is just an agent of the government. It is not that the director is given full power.
All right.
Director is the agent appointed by the government. The surplus fund of every such institution shall be invested in such a manner as may be prescribed and shall be utilized towards educational development only.
Only.
Yes,
Who will
now,
prescribe it? Who will prescribe? Who is the authority to prescribe?
because the scheme, it has to be in tandem with the scheme.
Okay.
Audit and accounts. The accounts of the non-government educational institution shall be maintained and audit shall be done in such a manner as may be prescribed. The
Now-
institution,
You encroach upon Income Tax Act.
yes, Lordship, next, Lordship is, now next point is very much clear. Who will
Yes.
do the audit?
Hmm.
Here it is see. The institution shall furnish to the director an audited
What is
statement.
what does your audit department do then?
No, our
What
audit
does the income
department will
tax-
not do.
What does the Income Tax Department do then?
No,
What is
who
it
will
for?
do?
This is
Now-
for the Income Tax Department, sir. There's nothing to do, director has nothing to do with the accounts of the school.
That can be
Absolutely no
Lordship's
business.
viewpoint. Our viewpoint is different.
Yes, all right.
Lordship may interfere. I have no difficulty.
We are just discussing the provisions which
Yes.
are apparently
I am also
offending,
giving our view.
apparently offending. They
Yes,
encroach upon
apparently offending,
certain
whether it is
statutes.
offending or not,
They are-
we are
They
testing
are
it. Lordship.
encroaching upon certain set of.
These are not
statutes.
their arguments, Lordship, at
They
all.
were very much
This
their
is-
argument,
This
Mr.
is not
Saikia.
their argument. I
Ms.
have noted down
Saikia, you were
every
not
argument.
there
This
yet.
is the argument of the Honorable Court. This is the
You have a
argument I'm
problem
giving
with that?
reply.
You
This
have a
is not their
problem,
pleaded
Mr.
case.
Saikia, do you have a problem with that?
I
That if
have
the
no
court is
problem
putting a
because
query,
they have,
we are examining the scheme of the act.
yes,
We have a
Lord.
right to make any
Yes.
query under the sky.
but they have not argued. They have not pleaded.
They
in their
have argued,
petition.
you are not here
Where
yesterday.
is their pleadings regarding that the audit is not done as per
They
the
have
Income Tax
said,
Act?
they have said the entire act is unconstitutional.
There's
every
a vague
provision can be
general
looked into.
statement. That is
Yes.
general statement.
All right,
They have to pinpoint it so that we can come out.
very well.
What is the rationale of this particular section?
Okay.
They have to individually indicate.
They have said that the entire act is contrary to
Their entire
19(1)(g).
Then I said on 2 points.
Yes,
On 2 points.
all right.
That we do not have the competency. My reply to that is that we have competency entry 25
Very well.
of the concurrent list.
Very well.
That is my answer.
Okay.
I don't have to go because when they have to challenge the whole act or individually each provision, they have to argue. They are not arguing all these things.
All right, all right.
They have directly come, Mr. Unni has directly come to the TMA Pice case. And the other case also we have noted down what arguments they are making. And their pleaded case is that they have no difficulty on this provision.
All right, carry on.
The institution shall furnish to the director an audited statement. Now, who will do the audit? It is under the income tax, like Lordship.
So why the director is supposed to receive the statement? Who is he to ask for it?
Under this.
So
act-
they are supposed to send the
under this
audited accounts.
act,
10 doesn't.
the Lordship will kindly see what is the rationale of this act. The rationale of this act is that to cut down the commercialization of education. Mushroom growth of schools in every nook and corner. Wherever there is some space, 3 rooms, they have an English school coming up there.
Why do these schools come up?
Why
Tell
do
us.
the schools come up? Because they have the affiliation from CBSE, they have the affiliations from other boards, and they.
Mere having affiliation is sufficient for the school to thrive.
That is what we are trying to impose here. The section 10 says, what are the
Saikya,
basic
please don't
requirements?
sidetrack the question.
RTA,
Mr. Saikya, don't sidetrack the question. What is the need for these schools to come up?
what is the need?
Yes, because you are not able to cater to the people.
We have,
That is the reason.
we have, but
You have
we
to
have,
admit to that. There is no dispute about it. That is the only
no,
reason.
when there is a demand,
Yes.
there is a
So it's a
supply.
question of demand and supply.
Demand is
All
there.
right. So it's a
Demand is
commercial
there.
transaction.
Demand is there,
Yes.
but when, because ultimately we have to see
Hmm.
that the students have to go and they have to get proper education.
Hmm.
That is number one.
All right.
And
Now
they have
let us come back to 22.2. What does the director do with the audited accounts?
List of properties.
What does the director do with the audited accounts?
Yes.
What is the use?
The
must be a
institution shall
purpose
furnish
behind
the
the-
director an audited statement of accounts at the closing of every financial year, mentioning clearly the total receipts and expenditure during the last financial year.
Hmm. What is the purpose?
The purpose is, Lordship, ultimately, we have to see whether everything is going on as per the scheme of things they have submitted under section 14.
Okay, very well. Yes.
List of properties.
Hmm.
Every non-government education institution shall maintain a list of properties, both movable and immovable, owned and possessed by it, and furnish the same to the director at such time as in such manner as may be prescribed.
Hmm.
Withdrawal of recognition and order of closure. Where any non-government educational institution fails to fulfill or comply with the provisions of the Act or violates any of the provisions of this Act or the rules thereunder, or any other order by the state government or the director under the provision of this Act, the state government may, now here none of the director,
Hmm.
the state government may at any time, after giving a reasonable opportunity of being heard, order for withdrawal of administrative recognition and closing down of the non-government educational institution.
Hmm.
The state government will step in.
Hmm. So where does the right of appeal go then? Where does the right of appeal go then?
Right of appeal, then 226 will open up. Because at that point of time, only one part was there.
So
When there is no door, when there is no remedy, 226, Lordship's door is there.
Obviously, that you need not prescribe.
Yes.
That they will use.
That door
Don't
is
worry.
always there. So
Yes.
if they are aggrieved by the state government's decision,
Hmm.
because the appeal is to be before the state government.
Yes.
So when the director will come to a certain conclusion that the provisions of the acts are not complied with fully by this particular school,
Yes.
then the director will report it to the government and government will take a call and government will do the action, will
Hmm.
take the action after due diligence, after following the principles of natural justice.
Yes.
It is not that the government will arbitrate.
Hmm.
If they can come up with satisfactory reply, Lordship, I don't think the government will be
Yes.
so harsh to stop or
Hmm.
close a school because
Yes.
it will have a ramification in the society.
Hmm. Okay, carry on.
Withdrawal of administrative record and closing down in the event of such closure, the individual association of individuals, non-government or organization, society or trust establishing and running the institution shall be solely responsible to the teaching and non-teaching staff, students, guardians and parents and other concerned persons or bodies, etc. The non-government education institution established and functioning in the state without being registered under section 4 shall be liable to be closed down.
Hmm.
And the event of such closure, the individual association or individuals, non-government organization, society or trust establishing and running the institution shall be solely responsible to the teaching and non-teaching staff, students, guardians, parents, and other concerned persons and bodies. So if they do not follow this act, Lordship, if the act is there, they have to follow it. If Lordship set aside, this thing is different. But if the act is there, till now it is there, they have to comply with it. And 99% have already complied.
Till date?
Lordship,
Why it has not been enforced till date?
it has been enforced.
No, we just told you that there is a writ petition in this code. Requesting a direction to the state
There may be.
to enforce it.
Huh? Oh, there's a status quo here. There's a status quo order.
In which writ? Which file?
In an I, one of the I's file.
Let's see, let's check. Where is the status quo?
Intention of the government is, Lordship,
We'll just,
very positive.
we are completing, Mr. Saikia. Let us see the intention. No, interim relief was earlier rejected, 16/5/2008, maybe thereafter. Yeah, 20th February, 22. 22. Yes, 15/10/15. Yes, all right.
Then liability to the chairman, etc. for punishment. Any non-government educational institution or school authority thereof failing to comply with any direction issued to it by the state government or the director in discharge of their duties under this act, the chairman, the president or the society or trust or the individual or association of individuals or any persons responsible for overall management of the institution or the owner thereof shall be held responsible and liable to be punished with a fine that may extend to rupees 10,000 for the first offense, and in the event of commission of every subsequent offense, the fine may extend up to 50,000.
Where is the offense defined under the act, sir? And what is the mode of prosecution? Is it a cognizable offense? It is a non-cognizable offense?
Here, it is not that criminal line is not there. It is simply
offense. That is why Ms. Saikia.
Yes, but here, all the thing is that they have to comply with the provisions of the act.
Failing which they are liable for punishment as an offense.
Here, that status has not been given that it will become a criminal offense. It is an offense under this act only.
Punishable with fine.
Punishable with fine.
So offense, what does offense mean?
Now offense from criminal jurisprudence, it is different. From civil, it is different.
Okay.
It has a civil consequence here.
Okay, very well. That's a new line of thinking. Good. Yes.
Assistance of police and civil administration. The director may, as and when situation so demands, take the assistance of such police force and assistance from the civil administration as may be necessary in discharge of his duty under the act. That means to inspect, to enter into the school premise, all these things. Jurisdiction of civil court was barred at the earlier point, Lordship. Now the appellate provision is there.
Still, civil court's jurisdiction is still barred. What gives you the right to do that, sir?
One is, Lordship. The appellate provision is there.
So what? The appellate authority is not subject matter to the jurisdiction of the civil court.
In lot of cases,
you just now said civil wrongs.
Yes, Lordship.
Civil wrongs have no remedy in civil law.
No. 226 is there. 226 is there.
Why should they come to the high prerogative writ jurisdiction? In everything. Questions of facts. You will oppose the writ petition saying that they are disputed questions of facts. Where will the litigants go? Tell us.
Their litigants can always, because it is all documentary evidence ultimately.
Yes, Saikia, please don't sidetrack the issues. We put you a simple question. You will oppose these writ petitions saying that these are disputed questions of facts. Where will they go? Can you ever explain this provision? Ousting the jurisdiction of the civil court.
Except as expressly provided, but there is no decision or order made in excess of this power.
Is there any express provision in which situation the civil court can be approached? There are flaws in the act. You have to admit that. The better way is now there are specific statutes. I told you at the beginning. take a decision.
Now,
Revise it
we
in
are
accordance-
arguing a case, Lordship, of 2005 Act.
That is why we are saying, Mr. Saikia, the flaws are apparent.
We will defend this Act tooth and nail, Lordship.
Very well.
It is, we are not going to
Okay.
concede, Lordship.
Carry on.
We
Okay.
are not going to concede. We'll,
Very well, very
we'll test it, Lordship.
All
If
right.
if anything has been done wrong,
All right. Very well.
if suppose that civil court's jurisdiction, that may be a flaw.
All
That may
right.
be a flaw, but
All
this
right.
was never argued and never pleaded. If that situation is there, Lordship,
Okay.
we can
very well.
always amend it. But how we amended in 2018, we
Yes.
have amended two parts.
Hmm.
One is that appellate provision we have inserted.
Hmm.
These are how 103 times the Constitution of India has been amended. So here, there are a lot of scope for amendment.
All right.
It is not that 2005 is sacrosanct and it will prevail over all times to come. No,
Very good. Okay.
that is why the amendments take place.
Okay. Okay. Very well.
Our high court rules are amended so many times
Yes.
with the
obvious-
new system.
Okay. Very well.
So if that is one area that civil fact-finding exercise is not permissible here under this act, we'll definitely take note of it, Lordship, and we may
Okay.
come up with
No,
a
you just now said that we are defending it truth and nail, so court
you
will
can
take
read
care of
the act, but
Yes.
this particular provision, one individual provision
it. Mr.
will
Saikia,
not
we are
make the
telling
whole
you,
act ultra virus.
Problem is that once you've taken a stand, you are not ready to listen. That is the problem.
No, I am,
We are suggesting to you that there are few legislations which have come in between. The act encroaches upon those legislations. You can amend the act accordingly and all things will be resolved.
Lordship, there is a doctrine of occupied field,
Hmm.
in which area we can occupy. There can be some occasional intermingling.
Okay.
That is permissible in law.
Very well, very well.
Let them argue this point, then I will have replies to that.
Okay, very
If
well.
certain areas are occupied by a central legislation, let them, that was my opening statement to this morning,
Yes.
that which central legislation we have violated, let them first point it out.
Okay, okay.
Now it is
Carry
coming out from this honorable court, not from them. Lordship said that income tax act is there, or the provident fund act
That
is
was
there.
the argument there.
This is
That
not their
argument,
argument, Lordship.
Oh.
This is not their argument.
without you being in the court, you will make a statement that this was not the argument. We should replay yesterday's proceedings.
Lordship,
We should replay yesterday's proceedings then.
no, whatever the noting has been taken, I have.
So
No.
that noting is more sacrosanct than what is coming from us.
No, I can go through the video recording.
All right, let us play it then. Let us verify the statement of the court then.
No, I'm not talking about courts, the other side statement.
Ms. Saikia, we are telling you 3 times, we have told you that that was the argument.
Let me stop today, Lordship, let me continue tomorrow.
Very well.
Or it can be adjourned for a little bit longer also.
No, we'll continue it tomorrow.
Yes, Lordship.
Yes. Arguments continue.
I'll go through the whole video,
Oh, yes.
then I'll come back.
Definitely. Yes. Arguments continue. Ms. Saikia, please for some time to prepare and complete his
No,
submissions.
not prepare, Lordship. I'll have to
Complete
just-
his submissions.
I have to just look at that may be recorded. I want
Complete
to
his
see
submissions.
yesterday's video.
Ms. Saikia, you will not dominate how we record the audio sheets.
No,
please.
but the thing, my submission is that I want, otherwise I'm not seeking
You can
adjournment.
do it. Who stops you?
Now it will be consuming court's time.
You do it at your will, at your time, at your
Highly
pleasure.
obliged, highly
Who
obliged.
stops you? Please, tomorrow.
Yes, sir.
Daily list, item number 1 to 5.
Yes. Yes. Ms. Mazumdar, you made a statement last day.
Yes, I went through the records which were given to me by the department, my lord. And those grounds that they had said would have some impact on this matter, they do not have. So
That's it, nothing.
So I think we can continue with the matter, my lord, once.
Argue.
Yeah, no, yeah, my lord, it will be on some other day, my lord.
Yes.
Hello, record me, hello. নতুনত্ব একটু নাই তো কন্টিনিউ করা গেলে কিন্তু বসলে মানে certain developments are there which may have an impact on this. Not there. Huh?
I'm not. The first appeal by you, another appeal by you.
Yes,
I am told, my lord.
He retracts his earlier statement.
I am told that the last speech on the Independence Day, Chief Minister has announced that he will.
No TET requirement.
No, he will regularize the contract teacher.
Contract teachers.
Because that is the bunch of whole matter.
So, Swami, prima facie feel that regularization is not possible. How that is possible in light of, in face of Uma Devi's job?
No, I follow them. What has happened in this, because this is the first appeal is by them, I think in the list, no? In the list.
First and second, both
First and second are both by the state.
Yes.
What happened, my lord? In 2010, the high schools, there was in very many high schools, 40 subjects, teachers were missing. It was not there. So they had to take a special decision and a special drive.
Contractual teachers.
For appointment as contractual teachers. By following the entire process of advertisement, the required setting of the papers, and then the normal regular process was followed. That as per rules. Then they were appointed on contract. Thereafter, they tried to impose TET. TET means Teachers Eligibility Test. The appointments were made in 2010. The rules were amended in 2012, wherein the TET was introduced, even for high school. We challenged that. And this single just to review that since they have already gone through a process which is akin to the regular process, the teachers' eligibility test is not required for them for two reasons. One, it has come after.
Where is that? Whether they were appointed against sanction posts?
They were.
There could not have been contractual teacher is never a sanction post.
No, posts were there. Teachers were not there. Therefore, they advertised. They had a special.
What was the mode of selection?
Mode of selection was exactly like the
regular selection.
Exactly right. It is harder than the rules.
Question then arises. Why didn't they go for a regular selection? Why contractual teachers?
That is for the government to answer, but this is how it was actually a regular selection.
They were vacant posts and it was a regular selection.
Because that was the whole purpose.
The notification says,
where is the notification? Let us see.
Page 66 of my appeal, first.
I have not really, I was hoping that the announcement.
Just a prima facie overview of the things. Prima facie overview of the things.
Page 66. Okay.
Yes. Yes.
Notification 10/6/2010. In pursuance of the cabinet decision to strengthen and to improve the quality of the secondary education, to engage 3 additional teachers on contractual basis in the core subjects of English, social sciences, mathematics, and general science of the school. Government of Assam formulates and notifies the following scheme. The scheme shall be called the scheme to strengthen.
So this is a scheme-based appointment. So law is settled. Scheme-based appointments are always coterminous. If the scheme continues, they continue otherwise.
Yes.
The agreements with the school, they have been continued. They are in continuous agreement with the school. They remain in the schools. What the bone of contention was whether to consider their regularization.
The same situation like para teachers in Rajasthan. They did it by the term para teachers. They've been regularized under a specific service. Service rules were carved out for them.
Yes.
Para teachers, they were inducted in service.
In our service rules, we use the system where we give them additional marks for their period of service already done.
Experience.
Yes.
Okay.
And the only bone of contention was for regularization, could we ask them to undergo a special table? They were only agreed because we asked them to undergo a special table.
For the purpose of regularization.
Regularization.
It was a very attractive opportunity as a matter of fact.
They refused it. Many have taken it. Most of the people have joined. They are now serving as regular teachers.
No, nothing of
Some
that. That is not correct. What has happened was, the teachers' eligibility test was introduced by amendment in 2012.
Understood,
These
sir.
people were appointed in 2010.
Understood.
And
What-
therefore.
What prevents them from acquiring that qualification?
No, now, my lord, we have challenged the very legality of the teachers' eligibility test for higher classes, teachers, graduate teachers. Why? Because this is framed under the 1993 NCT Act. Under the NCT Act, they framed regulations. The regulations will not prescribe teachers' eligibility test for primary stage and the middle primary stage, not for the higher stage. Therefore, we said that this is a central law which has already specified where that will apply. If you want to make a departure from them, then you have to follow the procedure prescribed under Article 254. That was the short submission. And thereafter, the court came to a finding that this test which is being prescribed is virtually the one which they have gone through is more rigorous than the one they are trying to.
That how the court could decide, sir?
No.
What was the
teacher
material with the court to decide that?
They are already in service. There is no question of judging whether they are going to be eligible for test.
Now that things have changed.
Now they are also part of that declaration because they have been all along fighting
Declaration?
for the regulation, and this declaration which has supposed to have come.
Mr. Mazumdar, has there been any declaration of the sort?
That is not required now.
Has there been any declaration of the sort? What is
Yes,
what Mr. Goswami is talking?
In a meeting or somewhere or in a public forum, I do not know, but I do not have any document.
No,
with me. As
that
of
is
now,
why
the
I'm
government has not
saying,
given me a document which says that-
Take instructions. If there is anything, because these people are serving for last 10 years.
Last-
They were selected regularly.
Yes,
The posts were vacant, no doubt about that.
yes.
Now they have.
So then if
one
the
more
state government is taking a
The
decision.
notification does not say that because the posts are vacant, then therefore we are taking them. The scheme says we are giving additional teachers.
No, because it
Your Lordship, please again, my lord.
Let us see.
Notification itself.
In pursuance of the cabinet decision to strengthen and to improve the quality of secondary education
So.
and
so
to engage
this-
3 additional teachers.
Yes. So then we will have to call for the status of vacancies on that day.
Yeah.
Why you require additional teachers? Did you have your strength full
No.
that you needed additional teachers?
No.
Then we'll need that statement.
Because there was vacancy,
speaker-
that notification says that there is vacancy.
Where does the notification say? Let us see. Let's read the notification, page 66.
Kindly see the subject. English, social science, mathematics and general science. They were empty in most schools. Therefore,
How
they
do we get that, sir?
The scheme will be called the scheme to strengthen and improve the quality of secondary education in the state of Assam. The scheme will be applicable to all secondary schools, both government and provincial in the state of Assam, except BT in the area and in the districts of North Kasar and Hill district.
Mr. Mazumdar, as a matter of fact, the qualification for these teachers was higher than the qualification you are prescribing for those graduate teachers in LP and ME schools.
These are for secondary schools.
Secondary schools.
Secondary schools. So they have to be higher.
So, because ultimately, this declaration which has been made now, because they have been agitating for the last 1 decade now.
Okay.
For their, not for that, but for their regulation and.
But what is the process of selection?
Process of selection
Process of
is
selection was
prescribed.
further recruitment rules. The further recruitment rules as was effective on that day, in
On that
2010, that is the selection
What-
process they have gone through.
So they were selected on the basis of regular selection process.
Yes.
Selection process did not have anything.
But then we'll have to just find out. Only one thing needs to be, that is the gap,
They are,
whether there were vacancies on that day.
Their grievance was below the regulation and now.
See the pleadings?
To.
That will become from the clear from the pleadings.
We had a proposal that we will regularize them once they acquire the TET eligibility under the special TET which was being held only for them. They came to the court at that point of time saying that we will not undergo the TET. If you want to regularize us as we are.
And ultimately we have challenged because that.
But now, Mr. Mazumdar, we distinctly recollect the Advocate General making a statement that the state government is abolishing TET.
Yes.
That has not happened as of yet.
This is the order.
That has not happened as of yet.
If that happens, then what?
Then if the government
So
decides.
even if it is in a contemplation,
It has come into
It has
papers.
come, it has come.
so let us wait for a while. Let that decision come, then this
I
they
think
can
it is
decide.
better because your lordship can have it.
Has
for
jointly
some
prayed.
other day.
List
Things will
after 8 weeks.
crystallize. Let us not. We have waited for so long, we can wait for another month or two.
8
Let
weeks.
them crystallize the decisions and then we'll see. All this bunch can go.
8 weeks.
Item
What
number
are the
6.
writ petitions for?
I have filed item number 4. Here we are praying for, my lord, regularization of our services. In fact, my lord, there is a scheme of the government of.
Yeah, but why do you have to come to the division bench?
No, my lord, my single bench is because the subject matter is and therefore it has been tagged.
Tagged. Because the single bench writ petitions of the association were allowed.
In fact,
Yes.
my lord, there is, I mean, there is a.
Subsequently,
scheme of the
because
government.
that decision has been taken for regularization.
There is a OM dated 3/3/16, my lord, which itself envisages, my lord. I mean, regularization subject to fulfillment of NCT condition, which does not include that.
But our government,
That's a-
our service rules include
No,
that.
my lord, the point which I am trying to, project before lordship is, when cabinet has taken a decision pursuant to which this OM was issued, where a particular department can take a contrary stand. They are bound by the cabinet decision, because government cannot speak in.
The secretary wanted to change that.
Yes.
And the learned single judge said, this is a cabinet decision, you can't change like.
What is your pleading regarding the cabinet decision in the
Yes.
appeal? What have you said about the,
That is the subject matter of the second appeal, my lord.
That is second.
what is your pleading in that regarding the cabinet decision?
They devised the policy, just a minute, they devised by 3/3/16, the cabinet decided that they should be regularized. But they made two groups. If you are fulfilling all the requirements of the
Including TET.
statute, you will be regularized in your post. If you have not done it, they have given them
Time.
period to acquire that.
Acquire the TET.
So that they can do, but they can continue their service against the post they are holding, which will be personal. If they can get that qualification from that day, they will be regularized. That was the policy.
Okay.
That they wanted to change by a secretary. So we challenged that and the court took the view, learned single judge, that this is a cabinet decision, you can't
But
change like
Ms.
this.
Kusami, we understand you properly.
Yeah.
You yourself are saying that there were two parts to the decision.
Correct.
One was regarding those persons who had the qualification of TET also.
No,
Then
not me. That was.
can we
not
see
it.
the OM, please?
Yes, my lord.
Let's
If
see.
lordship will kindly have page 61 of item number 4.
This OM was issued
3/3/16.
pursuant to the cabinet decision.
Yes, my lord. We are saying that please give us this relief, nothing beyond that.
Page 61 of item.
Item number 4.
Yes, Mazumdar,
WPC
Mr. Mazumdar,
1610.
why the state is not following its own OM?
Exactly.
Now this is a writ petition which asks the state to act as per law.
Yeah.
Right?
Ultimately,
What arguments were being advanced just a little while back, that the private individuals must act as per law.
That should also be.
My lord will kindly
Yeah,
come to
my
page 61.
61.
Yes.
Yes.
Office memorandum dated 3rd of March 2016. Subject regularization of services of additional teachers engaged on contractual basis under the scheme to strengthen and improve the quality of secondary education. Again,
Yes, in addition
sanction
to.
vacant post in schools under secondary and madrasa education as per approval of the state cabinet in the meeting held on 28/2/16, vide additional item number 26, the following instructions were issued. Schools under secondary education, that is higher education, high school, high madrasa and madrasa institution under madrasa education suffered due to shortage of teachers due to period prior to 2010. The regular sanction posts were vacant due to interference of the court of law in filling up vacancies of the said school institution. It was assumed that non-filling of the post basically in the core subjects in the regular sanction post is responsible for deterioration of the quality of secondary education in the state. Therefore, with the approval of the cabinet, the government in the secondary education in the state of Assam by notification dated 10th of June 2010, under which 3 additional teachers in core subjects like English, Social Studies, Maths, and General Science in each government and provincial school and madrasa were appointed on contractual basis. These contractual additional teachers were engaged in addition to the existing.
In addition to the existing sanction.
Yes.
Now, this is contrary to what they've said on top.
Yes. These additional teachers were engaged in addition to additional, yes, some were there additionally also appointed.
Okay.
Initially, they were appointed for a period of 11, but considering the need of
The
their.
need continues, so they are continuing.
Yes, continuing.
Okay.
Then my lord will kindly see under what condition it was proposed to be regularized, para 3. Therefore, considering all other aspects, the state government have decided to fill up the vacant posts in the cadre of graduate teacher in the government and provincialized high and higher secondary, etc., under madrasa education by candidate amongst the additional teachers appointed on contractual basis under the scheme to strengthen and improve the quality of the secondary education as per the following principle in order of preference. Contractual teachers who are in possession of qualification required as per provisions of NCT regulation for recruitment of teachers educations will only be regularized. They will get the pay and allowances in time scale of pay meant for the graduate teachers of the high madrasa, etc., from the date of their joining on regularization against the sanction post. For teachers who are yet to qualify, 1 vacant post will be identified against each of them. They will be engaged temporarily against this vacant post on prevailing condition at a fixed salary of so and so per month, and from the date of joining against earmarked post for a maximum period of 5 years. During these 5 years, they have to acquire the required qualification. These teachers shall be regularized against the earmarked post after they qualify as per the NCT.
So you are agreed by this condition.
No, we are not agreed.
No.
So that
We
this
implementation of this.
required qualification means what?
We had it, my lord.
That.
NCT, no, that was not there. That was introduced subsequently in 2012.
And that was not prescribed for higher education.
We had B.Ed with 50%.
We had already qualified.
Yes, we had B.Ed. And my lord, where is the question of TET? It's a key recruitment test. We itself are working. That's the view of the learned single judge.
That is only for appearing in the recruitment examination.
Yes,
That is a qualification. That is not an essential qualification
Exactly.
for appointment.
Yes.
And therefore, my lord, in that NCT regulation, they have prescribed only for the primary stage and the middle primary
Not for
stage, not
secondary.
for the
Secondary.
higher secondary.
That is not required.
No, it was not.
For
That's why we
secondary
challenge
level, although
because
B.Ed qualified teachers, Mr. Mozumdar.
the rules of 2003 as amended in 2012 had introduced the concept of TET in the secondary.
But they were
level
working
also.
from before. They were already inducted in service.
Well,
So what is
they-
the question of TET now?
They were contractual teachers, and to become
Maybe
regular teachers, they
Again, sanction posts. You're only
But they were
on.
not against sanction posts. They were additional posts. Sanction posts were vacant. So contractual teachers were
So-
taken, not against those posts. Not against those posts. They were specifically
Read the OM, read the OM top 3 lines.
my lord.
OM itself recognizes.
Improve the quality of secondary education against the sanctioned vacant posts.
Yes.
whole purpose was
Regularization of
to,
services of additional teachers engaged on contractual teacher under the scheme to strengthen and improve the quality of secondary education.
Against the
Against the
sanctioned vacant.
So the regularization will now come against the sanction post.
Right.
Their appointments are not against the sanction post.
This presupposes that sanctioned posts are still lying vacant. Right from the time of their engagement.
absolutely, your lordship is right.
Right from the time of their engagement.
In fact, there is an interim order of this honorable court that
And we
their
have been
posts will
given
be
sanction
taken.
post.
There have been submissions made, there have been concessions made. There are orders of this court, there is a contempt petition pending, saying that we have not kept the
Post vacant.
Post vacant and we have regularized everything. That is again pending before the learned single judge. It is not tied with this.
If the decision.
Our-
Anyhow, Mr. Mozumdar,
Let us wait for some time and let the government come to a concrete decision.
Then I think you will
We have-
take it.
I have
Learned
instructed.
counsel for the,
Could the lordships kindly permit me to place one paragraph from page 82 of my petition? Now, after that, my lord, state came up with that 14.7 whereby TET was prescribed. Now kindly see what is the contention of the learned First, second subpara, learned senior additional advocate general submit that the improved office memorandum that is 14,716 is intended for fresh recruitment of graduate teachers, including language teachers of Hindi teachers, classical teachers in provincial and higher secondary school, and would not cover the cases of contractual teachers working on the basis of notification dated 10/6/2010, who are covered by the judgment of this court and subsequent cabinet.
What have they said in their affidavit regarding OM? In this, you have filed an affidavit in this petition. What have you said?
This petition, this was disposed of. Lordship.
No. This petition, Mr. Chaudhary is arguing, item number 4.
In our case, they have not filed affidavit.
There is an affidavit. 1610.
Yes.
1610, there is an affidavit.
5660 is disposed, my lord.
1610, serial number 4. It's by respondent number 5 only. Garbi Anglong. All right, you file your affidavit. That will resolve the things.
No, let us wait for a while.
All right, in some of these bunch matters, affidavits are yet to be filed on behalf of the respondent state authorities. Mr. Mazumdar prays for and is granted 8 weeks time to do the needful. Published.
All this entire bunch, your lordship will have it after they get the.
We have postponed it by 8 weeks.
Absolutely. That's the best thing.
Okay.
My lord, we are awaiting something instead of 8 weeks, could be 4 weeks. Subject to-
No, why don't you know what is happening? I think your lordship is right.
8 weeks.
Item number 6.
Let it also come along with that, if they.
These are all connected matters, otherwise also. विद्यालय मंत्री संस्था 6. Yes, who is there for the petitioners? No one. Item number 6 is connected with that. Okay, 6 also goes with that. So connect kar dena. Connect with the so and so and list after 8 weeks.
Item number 7 and 8.
Yes.
So here in this writ appeal, my lord has called for a report, my lord, from the revenue department. I have received the instruction.
Let's see. There was a committee constituted.
There
But
was a committee constituted.
what
my lord.
happened? You last communication your place is that the report is missing.
Record is now missing, my lord. The department has already filed an FIR, my lord. And now the department has also constituted a committee, my lord, to be headed by the secretary of the revenue department, my lord, to investigate into the matter. The internal committee, I have, my lord, placed all that bunch of documents before my lord. So that is the practical difficulty as of now.
This is the sufferers of the ethnic violence. 93.
93.
And the file is missing.
File is missing. Because that is the old pending file. They came to this honorable court in the year 2016.
18, 16,
Yes.
16.
And only after 2016, my lord, this Indian order came to be passed, against which, my lord, the state have preferred these 2 appeals.
What is the order by the single bench?
My lord, the order passed with regard to the effect, my lord, that my lord is taking up, my lord, Writ appeal number 233. There, my lord will kindly come to. My lord.
What is the order dated 31/3/2011?
Absolutely.
That was challenged.
Yes, my lord. And this order was, my lord, impugned order herein is, my lord, 16/7/2015. Operative portion, my lord, will find at page 35 of the memo of appeal. Paragraph 30.
Yes.
The writ petition stands allowed with a direction to the state respondents to make compensation for the damage caused to the movable, immovable properties of the members of the petitioner society on the basis of the assessment reports prepared by forest and revenue officials. While ascertaining the quantum of compensation payable, it would be at the discretion of the state respondents to limit the amount to a maximum of rupees 50,000 per family, less the amount already received by way of immediate grant. Necessary action for taking effective steps towards compliance of this direction above.
So what is wrong in this order, please?
My lord, we have taken a categorical stand here in the appeal, as well as also, my lord, before the learned single judge, that, my lord, there were, my lord, the policy of the state was, my lord, to give effect, my lord, with regard to 4 categories of persons. Now, my lord, the 4 categories of persons, my lord, it was laid down, my lord, after a thorough fact-finding exercise. That, my lord, will find at page 54.
Yes, categories are
Page 54 of the memo of appeal. My lord, that is the order that 31st March 2011. That has been put to challenge, my lord, in the writ petition. There, my lord.
The order at page 54 is of 15th March 2010.
Yes.
2011, 31st March.
Yes, my lord, 31st March 2011.
That is at page 52.
My lord, and the apology, my lord. I'm taking this as a mistake. My lord, there, my lord, will find in the middle of that order, my lord, the first page, my lord, I'm reading it. My lord, 1, 2, 3, 4, 5th paragraph, my lord. The petitioners were affected in ethnic violence. Lordship got it, my lord. In the year 1996. But they returned to their respective villages and continued to lead normal lives. To rehabilitate
38,000 families remained in the camps.
Yes, well, to rehabilitate 38,364 number of families who could not go back to their respective villages and stayed back in the relief camps. The government of Assam prepared a 4-phase action plan and proposed to government of India to release funds by providing rehabilitation grant to each of the families at the rate of 10,000. The composition of the phases were, my lord, the phase 1, families owning patta land or previously residing in recognized forest village who could go back without additional security arrangements were included in this phase. Phase 2, families owning patta land or previously residing in the recognized forest village who could go back with some additional security arrangements were included in this phase. Then phase 3, families owning patta land or previously residing in the recognized forest village who could go back with additional separate security arrangement in each village or in cluster of villages.
Are these relief camps still continuing?
No. It has been discarded long back. Now, my lord, in the 4th phase, my lord, so far as the 4th phase is concerned, my lord, families who either had no patta land or were not resident of the recognized forest villages were included in this phase. The families required arrangement of land for rehabilitation. However, suitable land for rehabilitating these families include in the 4th phase could not be arranged for such families continued to live in different relief camps of erstwhile Kokrajhar districts. Moreover, a few thousand families affected in 93 violence who had no land to go back also continued to reside in the relief camps of erstwhile Kokrajhar and Bongaigaon districts. They have become a recurrent liability to the government of Assam since gratuitous relief in the form of foodstuff, blankets, mosquito nets are provided to them regularly besides providing civil amenities at the cost of public exchequer. Thereafter, my lord, the earlier writ petitions that has been filed, my lord, that has been discussed. Lordship will kindly come to the next page, my lord. The Honorable High Court in both the cases directed the government to pay rehabilitation grant to the petitioner families at the rate of 10,000 per family. This is not in dispute. Everybody has got 10,000.
That order has not been challenged any further.
My lord. In
Okay.
compliance of the order of the Honorable High Court, the government provided rupees 10,000 to each of the petitioners. It is not a fact that the government of Assam has taken any decision to enhance the rate of rehabilitation.
Okay, they
grant.
came out with a prayer to enhance the.
Yes, they
Okay.
said, my lord, that we want 50,000.
And what is that report? Then what is the purpose of that report,
My lord,
which we are searching for?
yes, my lord.
What is the reason?
My lord, that also, in fact, I cannot comment upon because that was, my lord, a statement with regard to the effect that a committee was constituted and a report was, my lord.
With the recommendations.
Yes,
Okay.
that only their statement was made in the affidavit filed by the state, but the report itself was not a part of the record.
Mhm.
So might be for that reason, Lordship had a pointed query on the last occasion.
Okay.
Anyway, but this speaking order will speak for itself.
Mhm.
Lordship will fix this matter for, because this will take place, my lord, it will take,
All right.
require
This
lengthy
vote
hearing,
was
my
already
lord.
as placed on record. Then we need not wait for the report. We'll decide the matter on merits. What else? As
So-
pointed out that the report, the file number RR 82 of 2007, titled Matter Regarding Constitution of Committee for Rehabilitation of the Affected Families of 1993 Ethnic Violence, 1996 and 98 Ethnic Violence, has not been traced out despite all efforts. The authorities have decided to initiate proper investigation. FIR has been registered.
Yes, my lord, that my lord will find it page 3 of that bunch of papers, my lord.
Proper investigation to look into the matter. So Borpuzari submits that the matter need not be deferred for the report and can be considered on merits. When do we want
Can it come after 2 weeks, my lord?
list for hearing of 3 weeks?
Only issue remains here, my lord, whether the provisions of Disaster Management Act 2005 can be roped in. They say their argument, it has to be roped in, we deny, my lord. That is the only precise issue.
Yes.
And so obliged.
See.
Item 9.
May I please? This is a case of mutation. This is a case of mutation also.
Mutation.
Mutation also.
Yes.
So in respect of the suit land, a separate suit has been filed by the present appellant as plaintiff, and that has been dismissed by the London Lower Court. And against that,
Appeal has been filed.
First appeal has been pending also. So no relief can be granted in this case.
Whatever happens will depend on the outcome of the.
Outcome of the.
So then what do you want us to do in this?
That observation may be made, whatever the question.
Then counsel for the appellant submits that the civil suit filed by the appellant regarding the land in question has been dismissed and the judgment of the civil court has been challenged by filing a first appeal. He frankly concedes that in view of this development, nothing survives for consideration of this court in this writ appeal, and the appellant herein may be left at liberty to take recourse of the suitable remedy after disposal of the appeal in light of the judgment of the appellate court, first appellate court. In view of the statement so made, the instant writ appeal is closed. You don't have it because. Okay.
Item number 10.
May I please?
Lordship, please to remember that a matrimonial matter between husband and wife. Right, it was taken up in a writ jurisdiction, and a small prayer was asked for. By bypassing the prayer without any pleadings, without giving an opportunity, a different prayer was granted, and it was fully heard by your Lordship, consisting of different combination. Now, my Lord, and after hearing it, my Lord, Lordship is to direct that we can explore the possibility of my Lord settlement, and that was also recorded. But we talked, my Lord, we could not arrive at. The difference between what they propose, what we propose, it is too much. So we could not settle it. Now the thing is, my Lord, Lordship, please, if Lordship permits, my Lord, I can go on merit, my Lord, again, because it's a different combination.
Matter, my Lord, Lordship's intervention. My Lord, Lordship wanted that why you keep the matter pending and all that.
We never wanted, it was just a suggestion. That's all. It was just a suggestion. Otherwise, their challenge is purely on legal ground. How the writ court can entertain a challenge to a decree of divorce.
Not only that,
Or a
not
talaq.
only that, what they wanted was only the notice issued by the registrar in registering the talaq. But the writ court said talaq itself is not valid. It was not at all an issue. It was not at all challenged.
No, it was the issue, my Lord. I am saying
No,
the pleadings
Lordship,
were there.
please see the prayer.
Prayer was, my Lord.
Mr. Agarwal, issue is whether it was in the domain of this writ court to entertain that.
Will kindly consider one aspect of the matter. My Lord, just may I point out, my Lord. My Lord, it is not a case that where, my Lord, talaq has been given. And thereafter he went to the, my Lord, registrar to get it registered.
So whatever,
Here
it was a matter of civil court.
it
You should have gone to the civil court. Writ court is a purely a private dispute interest between two parties.
And my Lord, the talaq,
Matrimonial dispute.
talaq was also not completed.
How was the writ maintainable, sir? Tell us.
My Lord, the talaq was given before the registrar, my Lord. Your Lordship will kindly consider that aspect of the
It is
matter.
not.
You get a declaration from the civil court
Family court
or
act
the
is
family court. Yes, family court.
section
Family
7,
court or civil
exclusive
court?
jurisdiction.
Family court.
Civil court
Exclusive
jurisdiction is also
jurisdiction.
not bad.
Where civil court jurisdiction is barred. Family court.
Not bad. So for this case,
So whatever writ jurisdiction, how could it have been invoked, sir? How was the writ jurisdiction
my Lord,
invocable?
my Lord, I am not arguing that, my Lord, the talaq can be, my Lord, declared invalid by the court. My Lord, here the case is such. My Lord, will kindly consider that aspect of the matter.
Mr.
And on the
Agarwal,
last occasion, I
just
said,
in order to ensure that there is some applicable settlement,
my Lord,
we gave you an
even
opportunity.
we are ready, my Lord, while lawyer saying something, my Lord, I am saying something, my Lord, why not the matter be sent to mediation? Let it be settled, my Lord. Your Lordship will kindly consider that, my Lord, 2 talaqs were given. So for Asan talaq, 3 talaqs are. 3rd talaq was not complete even.
Get a declaration from the family court that there is no talaq in the eyes of law. How the writ court can declare when that was not even an issue.
No, my Lord, your Lordship will kindly see pleadings were there, my Lord. I am not saying, my Lord, prayer may be, my Lord, right. My Lord, he may be right.
Let's see
My
the
Lord,
prayer.
my Lord is pointed
All
out,
right,
my Lord.
let's see the prayer. Then whether there was a prayer to declare the
No,
talaq by
prayer-
It is
prayer-
in page 12. I will read only the prayer and the operative portion of the order. Lordship, please see me at page 31. Page 31. This is the prayer. But what happened was, talaqul Asan mode was adopted. First talaq, it was given to the registrar. He registered it and sent them an information. Then second talaq, it was given to the registrar. He registered it and sent an intimation. Third talaq, it was affected. Thereafter, what happened was, for the first talaq, the intimation was sent. And for that intimation, they sent an objection. The registrar said, no, it is proper. Then they preferred an appeal, not against the talaq, but against the intimation and the registering. So even without registration, it is valid. That is what the act says. Now, in this situation, what they did was, they have approached the court, not challenging the talaq, but challenging the registration
giving
of
effect to
notice.
the impugned
In
registration
page
of
31,
talaq.
page 31, it is a prayer. Lordship,
prayer-
please see.
prayer, I
I'm coming.
There was no prayer then.
But my Lord, pleadings
Now-
were there, my Lord, the talaq is
Mr.
not valid.
Agarwal, there was no, the writ court does not have jurisdiction to entertain this challenge.
And in page,
How can you bypass the jurisdiction of the family court in this manner?
and another thing is, the order in appeal, my lord, it was not at all challenged. Lordship, please see page 16, only 2 paragraphs, small paragraphs.
Page?
Page 69. This is the order passed by the writ court. Page 69. This is the operative portion of the order.
Writ court. कर दीजिए बंद कर 69 years.
Yes.
Whatever. 18th, 20th September.
Whatever.
Whatever it suits you.
18th or 20th, my lord, either, my lord, subject to your lordship.
Whatever date suits you, sir. Whichever date is comfortable to you. Let
Let
us.
it be 2-0, my lord.
2-0 will be. Well, if it's preferable to have it on either Tuesday or Thursday,
Yes.
but otherwise it's your choice. Because nowadays we are taking up hearing matters every day.
Every day.
My lord, 28th, my lord.
28th
Is it
as jointly prayed.
28.
28.
If even if it spills over, my lord, to 29th, my lord, I can
That's
take
fine.
a call. Because I must concede, my lord, I'll go a
My lord,
little slow.
My lord, we can,
Take your time, sir. Yes,
September.
dispute regarding domicile kind of
My lord.
yes, fine. Okay, my.
as jointly prayed, re-notify on 28th September. The Ismaili matter could not be taken up because of paucity of time. Re-notify on 28th September as jointly prayed.
Deeply obliged, sir.
Item number 12.
Yes. Yes, Mr. Fukan, what happened?
Lord, the writ appeal, Lord. Your Lordship's convenience, I have prepared a flow chart, my lord, to understand the facts, which I hope will save the time of the court.
My lord, we'll take up the matter. One vital thing, my lord, we have filed an additional affidavit before the Honorable Single Judge, wherein, my lord, we have brought on record that the subsequent order, it's a technical point, my lord, subsequent order that was passed, that was not passed by taking the consent in terms of the procedure that is there in the executive rules of business. But unfortunately, that's not a part of the pleading, but I have the copies, my lord, I can hand it over to the Lordship.
That affidavit was part of the writ petition.
It was part of the writ petition. We had filed during the course of the hearing.
What order were you referring to in that?
My lord, we are referring to that the final order that was passed.
What is the date of the order?
My lord, the final order was passed on.
Final order?
Which was impugned before the Honorable Single Judge.
Is that 12th September 22?
27th April 21.
27 April 21.
And 5th May 21, those two orders.
27th April is of course impugned.
Yes, my lord, that is the order by which his seniority was refixed by WD, my lord. After
There is a subsequent
11 June 21, and my lord, the subsequent order is of.
Would we be requiring those orders spoken?
My lord,
We would be requiring those orders to be on record.
my lord, because what had happened in
27
the
421.
27 421 is under challenge in
Challenge in
the writ court.
Writ court. And my lord, in terms of, we say that that order was not passed in terms of the rules of executive business, and we have brought the notice because the minister's approval, it was done in the name of the governor, but the minister's approval was not there.
Okay.
My lord, what had happened, my lord, because we had filed an application for impleadment before the learned single judge. And that
There is one additional affidavit, Mr. Nair, which has been filed to bring on record material facts which have come to the knowledge of the respondent number 1 after filing of the instant appeal. Have you incorporated those in this?
No, that is, my lord, with regard to the maintainability of the
Okay.
associations.
Okay. That you have given up.
what had happened, my lord, we had filed an
Sort of.
This was what I am referring to. This was part of the writ petition, my lord. And the
Mr.
Honorable
Fukan, you
Single
would
Judge
be
has,
required to bring that on record.
Honorable Single Judge has also referred to that in his order.
I'm trying to explain that, my lord. What had happened was I had filed an application for impleadment, my lord, in the matter. And that application came to be allowed by the learned single judge on 9th June 2022, my lord. And this was not served to me. On 9th June 2022, in fact, my lord, the learned single judge even reserved judgment in the matter without even letting me file a counter affidavit also in the matter. That's also one of the grounds that I've taken in the
My
appeal.
friend was
But I
heard
can-
in details all along.
I'm not objecting to that, my lord. It's of course a technical plea, my lord, but if I can
Then-
begin, my lord, I can bring this on record if your lordship.
This has to be there. It was a part of the writ petition.
Yes, but
It
never
has to be
served on
there in
me.
appeal.
I have pleaded also, my lord, in my writ appeal that this was not served on me.
but I'll bring it on record if they give me a copy.
I'll
my
give
lord,
it to you now only.
So, Mr. Nair, you place it on record.
I'll place it on record. I'll place it on record.
maybe serve the copy. of-
Sure, I'll give you that affidavit.
Okay. So will we be concluding it today?
My lord, because just to make it easy for your lordships to appreciate the facts, my lord, I have
Yes,
this
my lord.
chart, my lord.
Let us know what
After
are
that, my lord, I'll have my submissions, my lord, and to judgments
My lord,
also.
if my lord wants to dispose it, I can just give subject to what my lord, my friend wants. This man was promoted in 2002 as assistant executive engineer.
Okay.
2002.
I recollect now. We heard it once.
Once, my lord.
Yes.
2002, he was promoted. 2005, an ex-cadre post of executive engineer was created and he was placed there. Then, my lord, subsequently, he was, my lord, encadred. After his encadrement, that was put to challenge before this honorable court. Subsequently, in 2014, that was, my lord, negated. Then what happened, my lord? He was promoted as
Superintending engineer.
Now, the complaint comes from the association to the, and many other people have filed also before the government. Government Somoto takes it up and, my lord, directs an additional chief secretary to inquire into the matter. The additional chief secretary inquires into the matter, finds that 2002 promotion, there was clubbing of vacancies, but as 12 years had passed, it was of the view that that need not be reopened. Then, my lord, the other promotions said you have to conduct a review and, my lord, do accordingly. Government directed for review. 2002 was not touched, my lord. Promotion as assistant executive engineer was not touched. But my regular promotions as encadrement as executive engineer and superintending engineer, after review, they were set aside. Set aside. I was allowed to continue as an ex-cadre executive engineer. This 2002 promotion was never touched.
Okay.
Then I come up before this honorable court, and there were other writ petitions also. They had not filed a writ petition, but individuals had filed a writ petition. This honorable court took up my case, took up my case, proceeded with the matter, and finally it came to a conclusion that although 2002 promotion was irregular, touched upon, but nobody made a challenge to that. So the honorable court left it aside at that. From executive engineer onwards, it started.
Left it open, if I may.
Be that as it may, it did not touch it, because the government, then it went and, my lord, upheld the government notification saying that delay and latches would have come into question if that challenge was presented before the court. Now the government having taken a decision, that delay and latches question will not come. 5/1/2015, that order was, my lord, upheld by the government. I go upon appeal. The appellate court reverses that order. Then SLPs are filed before the Honorable Supreme Court. Honorable Supreme Court does not touch upon the 2002 promotion as an executive engineer. It says, my encadrement as executive engineer, promotions, my ex-cadre post, promotion as executive engineer, promotion as superintending engineer, bad, amounts to a fraud.
I'm sorry to interrupt you.
Except so what? It
Amounts to a fraud.
Fraud. I'm
Your
telling
promotion.
my promotion.
In fact, it
as
goes beyond
executive
that.
engineer, superintending engineer amounts to a fraud. In the last paragraph, it says, writ appellate order is set aside and the honorable single judge's judgment is restored. Then, my lord, they place me at 100 in the executive engineer's list. I file an IA before this honorable court, saying that, see, this position is not correct. This honorable court in the first round, my lord, says,
based on 2002, you are entitled to your seniority.
I say what the honorable single judge has given me is 2002, take him as assistant executive engineer and wherever he goes, place him.
He should place.
Now, what they have done in the impugned order is, they have, my lord, said that, okay, you promoted in 2002, but your seniority will be as per your position in the assistant engineer, which, my lord, was never challenged, never put to challenge, and which had attained finality by the orders of this honorable court and the government orders also. So the honorable single judge has only given me, my lord, 2002, wherever I go, I go. Subsequently, I became a superintending engineer by review DPC, and today I am an additional chief engineer. No challenge to these orders.
Later order.
Later on,
after your lordships issued notice in my writ appeal, he's got two promotions, my lord, to the post of superintending engineer, then additional chief engineer. But be that as it may, my lord, the the whole controversy arises, my lord, from the promotion that he got. If your lordship may have my chart.
Promotion he got in which year?
If your lordship comes to the first point, bottom, my lord, on the left column, my lord, extreme left, bottom.
Assistant executive engineer.
Assistant executive engineer. He was given that promotion on 31st of May
That order has
2002.
never been challenged.
No, my lord, I'll come to that. My lord. After that, my lord, he gets the promotion of assistant executive engineer 19th December 2002, my lord, where vacancies of 2 years were clubbed, my lord, in violation of the rules, my lord. And there's a finding, my lord, to that effect by the inquiry committee, which was appointed, my lord, by the then Honorable Chief Minister, based on a complaint which, my lord, the association had filed.
Assuming so.
Yes.
Who set aside that order? Who touched that order?
No, the findings are there in that report, my lord, which have been upheld.
Now you expect that those findings should be given effect to after 21 years.
No, my lord. The findings have already been given effect to in the judgment, which in the decision which was impugned before the single judge, my lord. But
When
my
were they
point,
given effect?
my lord,
In which year were they given effect?
well, this was 2002 and this decision was 27th April 21. But the same the explanation which the learned single judge had applied, my lord, in the first round of litigation will apply here also, because this is a decision taken by the government, my lord, and they are competent to rectify their own mistake. And there is a finding, my lord, by the committee, my lord, which says that clubbing of vacancies was illegal and unlawful. That is something that
irregular, Mr. Pukan.
My lord,
It may have been irregular. Can
My
you
lord.
say it, that action was illegal?
My lord.
It may be irregular, that's true.
My lord.
But for an irregularity to revert the man back
In
after
fact, even
21
the
years.
learned single judge at paragraph 41 of the judgment, impugned
Yes.
judgment says so, my lord.
Yes.
Lordship may kindly come to page 380.
Come to page para 38.
Para 38,
37. 36 onwards.
36, my lord. Thus, the question that has to be decided is as to whether the observation of the apex code that fraud vitiates everything would be a valid ground for the state respondents to open up a settled issue. My lord, I may pause here. Nothing was settled, my lord, because, my lord, if your lordship notes that the judgment of the Honorable Supreme Court came on 23rd of October 2018. So the courts were all along seized of the issue as to the validity of his promotion. Only after that, a provisional seniority list was drawn up, my lord, where the issue of seniority first was considered. And I will proceed here, which had attained finality in terms of the common judgment and order passed by the learned single judge in WPC so-and-so, and which judgment has been restored by the apex court in Ajit Kumar Bhuiyan. In the present case, S.C. Das committee as well was well aware that the petitioner had got the benefit of clubbing the vacancies for the year 2001 and 2002 at the time of his promotion to the post of assistant executive engineer. However, the report of S.C. Das committee dated 16 December 2014 held that since more than 12 years had elapsed since his last promotion, and as in the meantime the petitioner had given the ex-cadre post of executive engineer personnel to him, the matter may not be reopened. The recommendation of the S.C. Das committee was considered and accepted by the State Review Board, and subsequently the notification dated 5th January 2015 was issued by the state respondents in the name of the governor, which accepted the recommendation of the S.C. Das committee and the Review Selection Board. Thus, the state government had, by its order dated 5th January 2015, taken a conscious decision not to reopen the issue of the petitioner's promotion from the post of assistant engineer to the post of assistant executive engineer. The state government had also not made it an issue before the courts. However, by impugned order dated 27th April 21, the state respondents have opened the issue of petitioner's promotion from the post of assistant engineer to the post of assistant executive engineer 19 years after his promotion to the post of AWE. This is not correct, my lord. I say with utmost respect, because the promotion has not been touched, my lord. In fact, he has been put in the cadre of assistant executive engineer right below the person who he superseded, along with 141 others seniors of his, my lord. And there is a finding to that effect which has neither been disputed nor been disturbed, my lord. And further, my lord, though the state respondents have not disturb the promotion of the petitioner from the post of assistant engineer to the post of assistant executive engineer. The petitioner has been given his seniority position in the cadre of assistant executive engineer as per his seniority position in the cadre of assistant engineer. This is his grievance, my lord. My lord, and I respectfully submit that this has to be done because this is the only way it can be refixed, my lord, to do substantial justice, my lord, to all the seniors who he wrongly superseded. The above facts give rise to a question as to whether an administrative action or decision in the form of the impugned speaking order dated 27th April 21 and can nullify or make redundant a decision of this court and the Honorable Apex Court wherein the issue of the petitioner's promotion to
We'll
the post.
first be required to look into this judgment in the case of Ajit Kumar Bhuyan.
Well, I have annexed it.
Well, let's
It's
see
not,
that.
my lord, it's not the Supreme Court,
We
the
have
SCC.
the single judges or judgment also, my lord. Para 129, my lord, page 120.
No, the Supreme
Para
Court
37.
decision your lordship will find, my lord, at page 160, my lord. I'm sorry, my lord, 23rd October 2018. My lord, it starts at page 150.
Come to para 41.
No, para
This
20
judgment.
21.
41 of this judgment, impugned judgment.
Impugned judgment. Yes, my lord, I was coming to that. My lord, para 41. On considering the submissions of the counsel for the parties with regard to the petitioner's promotion from the post of assistant executive engineer to the post of executive engineer, it is clear that there should not have been clubbing of vacancies of different years as it was irregular. This is admitted, my lord, by the learned single judge. As stated earlier, neither the state government nor the members of respondent number 8, that is me, my lord, had made any issue out of the same. This is, my lord, on the face of it incorrect because kindly come to page 70 for a moment, my lord.
But supposing you had raised an issue,
I had,
and that was not decided in your favor.
the
What is
issue of seniority never arose, my lord, then. Only the issue of validity of the promotion arose. Issue of seniority arose only after the whole proceedings culminated after the Supreme Court's decision on 23rd October 2018, my lord.
All right.
And I had taken this specifically.
Ms. Pukan,
My lord.
let's see the Supreme Court judgment then first.
Yes, my lord.
Yes.
No, but I'll just take your lordship just briefly to this point which I had raised at page 70, my lord. Because this is a report of the inquiry committee which was submitted, my lord, pursuant to my representation. And 70, my lord.
Okay. Read.
The Assam, I'll just skip the heading, my lord.
Relevant part.
Yes, my lord. On para 2, my lord. On perusal of the memorandum, it appears that the grievances of the Assam Public Works Engineers Association can be summarized as follows. Shri Debojit Das was first promoted to Assistant Executive Engineer in the year 2002 from Assistant Engineer of 96 batch, superseding 163 graduate engineers. So this was a grievance I had raised specifically, my lord.
Finding.
Well, the finding your lordship will find at page 72 first, my lord. Lord, I'll come to the relevant part straight away, my lord. Page 72, my lord, about 7 lines from the top. On examination, my lord, has it? On examination of all the relevant records available in the file number so-and-so in respect of promotion of Sri Debojit Das from Assistant Engineer to Assistant Executive Engineer, it is seen that the DPC was held on 19th June 2002. The vacancy position of Assistant Executive Engineer was shown as 57 and accordingly 228 numbers of officers were covered under zone of consideration. In the gradation list, the name of Sri Debojit Das was at serial number 164 as Assistant Executive Engineer on 31st March 2002, but in the list showing the zone of consideration, his name is 142. From the minutes of the meeting held on 19 June 2002, annexer so-and-so, it appears that he was selected by superseding 141 numbers of officers in the zone of consideration. This anomaly has been now addressed after the decision of 27th April 21, my lord. 67 members of the officers above him secured less marks than him. From the ACR grading, Sri Debojit Das has secured 20 marks, 5 outstanding for ACR for 5 years. The DPC held on 19 June 2002 selected 58 numbers of officers for promotion to the post of Assistant Executive Engineers. The name of Sri Debojit Das figured at serial number 1 of the select list. From 164, he came to 1 million. Thereafter, by notification number so and so dated 28 June 2002, the select list was published where the name of Devojit Das was serial number 1. It is seen from the note sheet page so and so. The vacancy was for the year 2001 was 2023. For the year 2002, it was 21. The state level empowered committee cleared to fill up the vacancies for 49 posts. The minutes of the selection committee has been made for 57 numbers of posts, 58 numbers of officers have been selected. It is clear that vacancies of the year 2001-2 were clubbed, and as a result of the zone of consideration was extended to cover large number of officers.
We understood.
Milord, so my point is, Milord, that this person was subsequently found to have got 3 promotions fraudulently, Milord.
Superseding.
And the Supreme Court has clearly rendered categorical strong observations that Milord, there was favoritism, manipulation of the system, and so on and so forth, Milord.
Let us see that observation.
My lord. May it kindly come to.
But what was decided in the writ petition of 2050?
Milord, 15, Milord, what had happened was, because the inquiry report, as I pointed out, Milord, said that the clubbing of vacancies for 2001 and 2 was bad, Milord. But we are not going into that, Milord. We are not touching that promotion. That's what they said. And that was, Milord, accepted in the government order, Milord, which came on 5th January 2015. That was challenged by them, Milord, before the learned single judge in the first round of litigation.
Why were they supposed to challenge it?
Milord, because what the order did was, the order reverted him back to the post of ex-cadre executive engineer.
Okay.
Milord, and then what had happened was, the learned single judge upheld that order and also found serious irregularities and fraud, Milord. And when they raised the issue of, Milord, limitation, the learned single judge specifically said that fraud vitiates everything and it cannot be brushed under the carpet, Milord. Then, Milord, they went up in appeal before the division bench, and it was the division bench reversed the judgment of the single judge, and we went up before the Supreme Court along with the state, Milord, and some other senior engineers. Now, the Supreme Court, Milord, at page 166 onwards.
There are 19, page 162.
My lord.
My lord will have 154 para 9. The issues we both.
Page 1, para 19, shall I come to, Milord?
No, let's
154. Para 9.
We have heard the learned counsel for the parties. The issues involved in these appeals are whether the promotion of respondent number 1 to the ex-cadre post of executive engineer and encadrement thereof subsequently is illegal, whether the delay and latches will come in the way of appellant number 3 in the challenging the order of promotion of respondent number 1, and see whether the government was right in conducting an inquiry when the writ petitions were pending before the court, and whether subsequent demotion of respondent number 1 to the ex-cadre post of executive engineer is illegal.
Pertains to promotion of respondent number 1.
And his seniority vis-a-vis 3 appellants in the appeal arising out of the special leave petition so and so. The other 2 appeals are by the state of Assam as well as Assam PWD Engineers Service Association, that is us, who are supporting the 3 appellants in the aforesaid appeal. For this reason, they also assail the impugned judgment dated 7th August 2015 of the High Court. However, for the sake of convenience, the parties shall be referred to with reference to the appeal arising out of the special leave petition number so and so, that is the appellants and respondent number 1 respectively. Before proceeding further, it would be apt to discuss the manner in which the division bench of the High Court has proceeded with the matter resulting into the aforesaid outcome. After taking note of the seminal facts which have already been stated above, the High Court summarized the findings of the learned single judge in the following manner. The encadrement of the appellant to the post of executive engineer is illegal, as the date when the appellant was promoted from the post of assistant executive engineer to the post
this was only dealing with the AEE 2E executive engineer. No issue regarding his promotion as assistant executive.
Milord, what this Supreme Court does, Milord, if I may respectfully submit, it goes beyond what the learned single judge had held, and even beyond what the inquiry report and the 5th January 2015 order had held. Those orders, including the learned single judge's order, go into only, take him back rather, and revert him to the post of ex-cadre executive engineer. Milord. Now, your lordship will find, I'll come to the conclusion of the Supreme Court. Milord, may permit me to read para 26 onwards, Milord. Having regard to the circumstances, I'm reading page 166, my lord. Having regard to the circumstances in which respondent number 1 was given promotion to the post of executive engineer by creating an ex-cadre post, and thereafter the manner in which he was encadred to the said post by stretching the number of vacancies against the record, speaks volumes about the manner in which undue favor was shown to the respondent number 1. One has to keep in mind that at the time he was working as officer on special duty to the chief minister. These facts reflect clear manipulation of the system at various stages to give out of turn promotion to respondent number 1 by bestowing undue favor. With such flyover promotions, respondent number 1 parachuted from assistant executive engineer to superintending engineer by bypassing many senior colleagues in the cadre of assistant executive engineer who are still stagnating in the same cadre. When this factual position emerged on record and was duly approved by the division bench as well, we are of the opinion that the writ petition could not be dismissed on the ground of delay and laches. In fact, the division bench has erred in invoking this.
Now we come to this, supposing that promotion is question. But since the fact has come to light that your promotion was wrong, this is a conclusion that vacancies were clubbed. So if you are not entitled to be promoted, assuming we save your promotion, you'll have to go to the bottom of it.
My lord, that is what I'm trying to say, my lord.
Yes.
My friend has not read page 90 of the inquiry report, wherein it said that the promotion will not be touched. No, I'm coming
We are
to
not
that.
demoting you.
My lord,
but
the
issue is of seniority.
my lord, the issue, it's not of seniority with regard to assistant executive engineer. That was never the issue anywhere, my
It
lord.
was only of seniority in this round
It's
of
only of seniority.
My lord,
We save your promotion, but can you get the leverage
my lord, that
of
was
going over so many people?
My lord, I did not go.
Yes.
That's the issue, my lord. My lord, my friend has beautifully put it. I credit him that. What he has said, my lord, I was at it was not me who had clubbed the vacancies.
It was how it happened.
No,
How it happened
no,
is apparent.
No, it's not that. That time he was a non-entity. My
we don't
lord will come back to the findings. My lord, I'll clarify it now only. My lord. My lord will come back to the findings of the inquiry report. My lord.
All right, Mr. Nair, will continue later.
Lordship.
When
My lord, what had happened here, 2001, 2002 was approved together. Not only me, my lord, there were many officers who were there. And how I came at serial number 1? Because, my lord, it's merit with regard to due regard to seniority. And if I come within that 20, my lord, I come in category A. That is how I came to some serial number 1.
You would have been considered against the 2001.
Not only me, my lord.
Mr. Nair, your client could not have been considered against the 2001 vacancies. They were a different class. So this exercise can even be undertaken now. Separate the 2001 vacancies. Only those who are entitled.
Then, my lord, not only me, all those who were there, 57, 58 persons, all will have to go, my lord. I was only targeted. 57, 58 persons who were promoted, all will have to go. They have not raised the grievance against those persons who have also come up, my lord.
Because of the clubbing.
Because of the clubbing, 58 persons had come up, my lord.
Findings are only against him. He has not
that's
disturbed those findings.
Subsequent promotion, Mr. Pukar.
That's with regard to
As
subsequent
the
promotions.
first promotion of 2002, there is no allegation of fraud in that.
No, my lord.
Irregularity.
Irregularity and that's
just hold on.
Yes.
For that irregularity, as Mr. Nair says, there were 57 more persons.
Yes.
Why one person should be singled out?
No, my lord, he is the one who got unlawful promotion according to us and
Later.
My lord.
First, the promotion to AEE.
Yes.
By clubbing the vacancies was not granted only to him. That benefit of clubbing, how many people got?
57, 58 people.
An undue promotion was given only to him, my lord. I'll make good, my lord. I'll make good.
All right, let's argue that. The issue which you will have to address is whether you can raise this issue now. Raise the issue of undue promotion of 2002.
Well, because that
my lord
issue,
will
as I
see
said, my lord, arose
the
for the
impugned
first
order.
time only post.
What they have done, my lord, they have taken selectively from the inquiry report, selectively from the single judge's order, and then my lord passed the order.
23, re-notify on 26th September.
Lordship.
Other matters give a date.
Lordship.
Other matters you can give date.
In item number 15, 16, and 17.
So sorry, could it be 28th, my lord? Sorry.
28th
28th September, my lord. Obliged.
28th only. 28th. 28th we have fixed that second matter might take time. Might consume.
My lord, can postpone it a bit more, my lord.
We can fix it in October then,
Lordship,
5th October.
Lordship.
Or 5th October.
Well, in item 16 and 17, Lordship has directed
Rubber
us-
board.
rubber board, the concerned officer of the board to be present with the records. Well, he has come with the records.
Tomorrow.
His,
We'll take these matters tomorrow. Yep. Tomorrow. we already have-
the officer has come from Kerala. my lord.
We remain for 2 days. What is the problem?
He's supposed to, his flight is tomorrow, actually. Records are here, my lord.
You return the records then.
Yes, yes. Well,
The officer in charge is present.
Lordship.
With the record. The matters cannot be taken up because of paucity of time.
Lordship.
Mr. Nara, you can retain the records with himself.
Well.
He notify on 14th September.
Lordship. The personal appearance is dispensable.
We never required his personal appearance.
The Lordship
It
has.
was only for the purpose of.
Lordship.
Yes.
Lordship, it is.
So actually
It is-
voluminous record, so he was calling that.
The officer need not remain present on.
No.